Yes.
Please, Your Lordship. Your Lordship, on last Thursday, the WPC number 2 of 2023 was heard and it was kept part heard.
Yes.
And that was supposed to be listed today, but it was not in the course list. So we pray that it may be taken up after the admission matters today.
Lordship has heard for nearly 4 hours the other
Yes.
day, and then it was kept part heard. But unfortunately, the matter is not listed today. I don't know what is wrong.
There's a supplementary cost list. Maybe you didn't see that.
It's listed. I'm told in the supplementary list it is there.
Oh, is it? Okay,
Then immediately up to
I have
the
not seen
admission
that one.
matters that may be taken up.
Sorry.
We did not get in the
It can
website.
be part heard, but it appears to me, okay, that in the last court date when it was listed for admission hearing or what?
Yes.
Yes.
Then I'm saying, okay, since I'm leaving on Friday itself, then maybe we will admit the matter and then list it for full hearing. I don't know,
Your
because
Lordship-
if we hear it today is Tuesday.
It
Since
was taken
the
up for
matter has
admission
been
hearing,
heard-
and my learned friend has already completed. And the counsel for the state has also virtually completed, and he was just about to cite the citations. And then only my part is left, Lordship. For
And
respondent
after
number
his part,
three.
I may reply in short.
Okay, I'll have to carry it home
we can
then.
complete today, Lordship.
I'll have to carry it home because I will not have the time to complete my
Okay.
judgment. That's the main thing. Had it been heard, completed the last time, I would have time during the weekend,
Yeah.
at least to write my judgment.
Okay.
That's the only issue.
Otherwise, I'm told it is listed in the supplementary list.
Supplementary. So we can admit the matter.
Lordship, it was taken up
Part heard.
on the ground that the matter is fixed for admission hearing. And then the Lordship has heard for nearly 4 hours
Yes.
the other day.
Having heard it, we will admit the matter and list it for full hearing.
Your Lordship,
I know, I'm a
there's,
little bit concerned because then I'll not be able to do justice to the case.
there's
Given the short-
urgency in the matter.
But I'll most probably have to carry it home because I have the other CAVs which I want to complete while I'm here. Okay, carrying this fresh CAV, I might not be able to
So,
pronounce the judgment during my term here. Others I'll be able to do it. I'll have to carry it home anyways. So I think what do you say? If you say we have to have it, it's okay, we'll hear it, but I'll have to carry the file home and it'll take time for me to write the judgment because I'll have other cases coming up in the
That is okay, Lordship.
Aizol bench. Okay.
That's
Your
all right.
Lordship's suggestion
that's all right.
that even if it's not that the judgment should be delivered as and when Lordship is sitting here,
No,
then as and when
but
Lordship
I'll have
can
other
have
cases
your own
coming
time.
up in the Aizol bench. I'm giving my full concentration to the Nagaland bench right now, Kohima bench. Okay.
Yes.
Once we go back to the Aizol bench, again pressing matters, then but it's okay. I can do it. I can carry the file. It's not
Lordship.
such a problem.
Lordship.
Only thing is the judgment it not be as quick as I would have liked because my full concentration
problem,
here is in the
Lordship.
Kohima bench while I'm
That's
here.
right.
Okay. Right, fine. After the first part, we'll do it.
Your Lordship. Yes, Your Lordship.
Oblige.
Yeah, please, Lordship.
Yes,
Lordship, I beg to mention item number 10.
10.
Yes. Lordship,
Yes.
this matter was heard by Justice Nielsen on 28/3/2023. And in view of the first constitution, Lordship, Justice Nielsen is supposed to be sitting today.
Yes, yes.
But then, in view of changes in the constitution, Lordship, we agree that this matter will be listed before Justice Nielsen.
Okay, was it part heard?
Yes,
Although it is not reflected in the order, it is part of Lordship.
it's part of.
Okay. Heard Mr.
What is it?
Watizame, learned counsel for the petitioner, along with Miss
Livika, Your Lordship.
Lily, the learned government advocate. Both of the learned counsels for the parties have submitted that this matter was heard at length by the bench, uh, the bench constituted of Justice Nelson Silo, and that this matter may be placed again before him. In view of the above, registry to do the needful and list this matter before the appropriate bench.
Please.
Now, please, the Lordship, please to mention item number 2 and 3.
2 and 3, yes.
The Lordship, 2 weeks may be granted for filing additional affidavit, Your Lordship.
Okay, heard Ms. So-and-so, learned government advocate, who has prayed for further time for filing of the
Additional affidavit. Much obliged, Your Lord.
Ms.
Malinrutsa.
Marimjitsa appears on behalf of the petitioner. This is matter after 3 weeks.
2 weeks, Your Lordship.
2 weeks, this is matter after 2 weeks.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item 18 to 29. This is our analogous
Yes.
matter, Your Lordship. Here, Lordship, the 18 to 22, the state has already filed its counter affidavit. However, in respect of item number 23 to 29, we are yet to file. A 3 weeks time may kindly be granted to us so that we can file the affidavit in these items also, Your Lordship.
Okay, heard Mr. Enangami, learned counsel for the state respondents, learned government advocate for the state respondents, who has prayed for time for filing of the counter affidavit in respect of items number 23 to 29. We can mention the WPC so-and-so. Mr.
Your Lordship, on behalf of Mr. P.B. Paul, counsel for the petitioner.
Mr. So-and-so appears on behalf of
Mr.
the
P.B. Paul.
Mr. P.B. Paul, learned counsel for the petitioners. In view of the above, list this matter after
3 weeks, my Lord.
3 weeks.
Deeply obliged, my Lord.
Right, ma'am. May I please, Your Lordship? Lordship, I beg to mention item number 33, Your Lordship. Lordship, here the counsel for the petitioner, the leading counsel, Tali Au. Lordship, he is not well, Your Lordship. He's having some health issues. So if Your Lordship may kindly list this matter after 2 weeks, Your Lordship.
Okay, heard Mr. So-and-so,
Yes.
learned counsel appearing on behalf of Mr.
Tali Au.
Tali Hao, 32?
33. ma'am.
33,
Yes.
okay, in part of Mr. Tali Hao, mentioning that the learned counsel for the petitioner is indisposed and has paid for time. In view of the above, list this matter after 3 weeks.
Your Lordship. Right, ma'am.
May you please, Your Lordship? Your Lordship, I beg to mention item 31. Let the matter be posted on Friday, coming Friday, Your Lordship. I have taken the consent of the
No,
petitioner.
no, not on Friday. We'll make it on a Monday.
Yes, Lordship.
Mm.
Item 31, 31.
Heard Miss
Mrs.
Lucy, learned government advocate for the state respondents, who has prayed that this matter be adjourned and be listed on, what's Monday? 1/5/2023. Mr.
Elikas Sangdamala for the
Elika
petitioner.
Sanke Sankam, learned counsel for the petitioner, is present. In view of the above, list this matter on 1/5/2023.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 11. My seniors in disposal, let the matter become up after 2 weeks, Your Lordship. Item 11,
Heard Mr.
Tushitamjan.
Tushi Chamjam, who makes mention on behalf of his senior, Mr.
Istamjan.
S. Tanjan, who is said to be indisposed. In view of the above, list this matter after 3 weeks.
Much obliged.
May I please, Your Ladyship? I beg to mention item number 32 of the hearing list.
Yes.
I pray that this matter may be listed after 2 weeks.
Okay, heard Mr.
N. Longcomer,
N. Lumkam Kumar, learned counsel for the
respondents 1, 2, and 6.
respondents number 1, 2, and 6, who has prayed for adjournment of the matter. Mr.
Your Lordship, I'm appearing on behalf of the counsel for the petitioner, Lima Wapang.
Mr. So-and-so appears on behalf of Mr. Lima Wapang, learned counsel for the petitioner. In view of the above, list this matter after
2 weeks.
2 weeks.
Obliged, my lord.
May I please,
May I
Your
please, Your Lordship? My Lord, I beg to mention item number 7. I have taken consent from the opposite party, so kindly allow me 2 weeks' time, my Lord.
Okay. Mr. So-and-so learned government advocate has prayed for
3 weeks' time, my Lord.
3 weeks' time for filing of their affidavit in opposition, Is it?
Reply to the
Okay.
counter reply.
for filing of their counter reply, and that the consent of the opposite party has also been taken. In view of the above, list this matter after
3 weeks, my Lord.
3 weeks.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 34.
Yes.
Lordship, the principal counsel is indisposed. Let it come up after 4 weeks, Lordship.
Mention is made on behalf of Mr.
NK will come, Lordship. I'm sitting.
NK, okay, heard Mr. So-and-so who mentions that the leading counsel, Mr. NK Linkham, is indisposed and prayed for adjournment of the matter. In view of the above, list this matter after
4 weeks, Lordship.
4 weeks.
Lordship, there is an interim order.
Meanwhile, the interim
Let
order
it be-
passed earlier shall continue till the next date. Yes,
My lord, my name may be reflected in the course, is my name. For the counsel for respondent number 6, my lord.
okay, Mr.
Elika Sesang, my lord.
Elika, your name is not mentioned in the cause list?
Yes, my lord. It's not
Yes.
reflected.
Mr. So-and-so, Elika, essay appears on behalf of respondent number
6, my-
6,
yes.
along with?
Yes,
In
for
all,
res-
I'm for the state respondents, Your Lordship, 1 to
along-
5.
Along with Miss So-and-so, learned counsel, learned government advocate for the state respondents.
May I please, Your Lordship? Lordship, I beg to mention item 4 on behalf of Mr. Yangarwati, CGC, for respondent 1 and 2. Lordship, we are yet to receive instruction, so kindly grant us 3 weeks' time.
Heard Miss
Diazenokiso,
Jason Lokusu, who makes mention on behalf of Mr.
Yangarwati,
Yangarwati, learned CGC, praying for time for filing of their affidavit,
uh,
since they have yet to receive instructions from the respondents. Yes. Miss
Marlene Rutza,
Melu Mitza appears on behalf of the petitioners. Learned counsel appears on behalf of the petitioners along with
Lordship, I will for the state respondent 3, 4, and 5.
along with Mr. N. Angami, learned government advocate for state respondents number
3, 4, and 5.
3, 4, and 5. Yes. In view of the above, this is matter after 3 weeks. 3 weeks. Yes.
Lordship, I beg to mention item number 8 and 9.
8 and 9. Yes.
I'm for a petition. My senior is indisposed, Lordship. Therefore, matter may be listed after 2 weeks.
Heard Mr.
John.
Johnny.
John.
John.
On behalf of my senior.
Okay. Who makes mention on behalf of his senior, Mr.? What's the name of your senior?
Tablar Anguli.
W.R. Wungli, learned counsel for the petitioner, who has prayed for adjournment since Mr. W.R. Wungli is said to be indisposed. Ms. Shukri appears, additional AG appears on behalf of the state respondents along with Mr.
L. Uralu.
L. Uralu, learned counsel for
Private
respondents,
private
for the private respondents. In view of the above, list this matter after 3 weeks.
Lordship, a similar prayer for item number 1.
Okay, so and so. Who is your
Here.
counsel here? Who is the counsel for the petitioner here?
I'm for the counsel.
Okay, you are for
Here,
the
I'm for a respondent number 4.
respondent. Okay. Heard Mr. No, mention is made on behalf of Mr. W.R.
W.R.
Mule,
Mule, yes.
learned counsel for the respondent number 4, praying for adjournment since the learned counsel is indisposed Mr. L. Iralu, learned counsel for the petitioner, is present. In view of the above, list this matter after 3 weeks. Yes.
Pleasure.
With pleasure, Lordship. Lordship, I beg to mention item 14, 16, and 17.
14, 15, and 17.
Yes, Your
Not
Lordship, I am
16?
representing the state here.
Okay. So, counter affidavit, most probably?
Yes, yes, yes.
Heard Mr. So-and-so, the learned government advocate appearing for the state's respondents, praying for further time for filing of the counter affidavit.
I'm for the petitioner in item 17. I pray that the interim order may be continued.
Okay, in item number 17, Mr. L. Iralu, learned counsel for the petitioner, is present and has prayed that the interim order passed earlier may continue. In view of the above, list this matter after 3 weeks. Meanwhile, interim order passed earlier shall continue till the next date. That is for item 17, okay? 14 and 15, 3 weeks' time is given. Yes.
Your Lordship, I beg to mention item number 15.
We've just mentioned 15 now.
15.
14, 15, and 17, 3 weeks' time, isn't it?
15th.
15.
You had mentioned 14, 15, and 17.
Maybe 14, 16, and 17, my lord.
Yes. It is 14, 16, and 17, not 15.
Lordship.
Your Lordship, item 14 is mine. I'm appearing on behalf of
Okay,
the
yours.
respondents.
So
Yes,
we
I'm
will
yet to
mention
file-
your name, learned government.
Yes, I'm yet to file my counter. I may be given 3 weeks' time to file
Yes,
counter.
time for filing counter, we have given 3 weeks' time, only
Yes.
that your name will be mentioned,
Yes,
okay?
Your Lordship.
Now 15, item number 15, I thought we just mentioned item 15. Who is appearing in item number 15?
Your Lordship, I am appearing on item
Okay.
number 15, Your
So
Lordship.
in item number 15, we will mention Mr. Enangami, okay? Now 16,
No, Your Lordship, 16, no.
16 is mine.
okay,
Your Lordship,
16?
I'm yet to
Yes.
receive instructions.
Okay,
I may
so
be given
further
3
time for
weeks' time.
filing of the affidavit in opposition.
Yes, Your
Fine.
Lordship. 3 weeks' time maybe.
Yes. Now in 17, interim order passed earlier shall continue. Okay. Next.
Lordship, in 15 also, if 3 weeks' time can.
Yes,
3 weeks.
3 weeks, in all these, 3 weeks' time have been granted.
Deeply
These
obliged.
State respondents, yes.
Deeply obliged.
My Lord, please allow me to mention item number 4. I'm appearing on behalf of N.K. Muri, the Learned Counsel.
I think we have passed an order.
Item 4.
Yes, 4. Please check. Further time has been given for filing of the additional affidavit.
My Lord, I was not informed that they will adjourn.
Yes, 3 weeks' time has been
My Lord,
granted.
I have, on the instruction of the main counsel, please allow us to implead the private respondent and also allow us to file additional affidavit.
See, if I'm not mistaken, in item number 4, time was granted for file, 3 weeks' time has been granted. Now we want to implead some people.
Yes,
Okay.
yes, my Lord, want to implead a private respondent.
Okay. In number 4, heard Mr.
Pakin Richabo, on behalf of N.K. Muri.
Pakinit Chabo, who appears on behalf of Mr.
N.K.
N.K. Muri, learned counsel for the petitioner, who mentions that they may be allowed to file an impleadment application with respect to some private respondents. Praise
Yes, my Lord.
allowed.
An additional affidavit.
Additional affidavit, I think, has already been mentioned. Okay. And for filing of an additional affidavit.
Yes, my Lord, on behalf of the petitioner.
Yes.
And my Lord, may kindly visit on 18th of May.
Who had appeared? Just check item number 4. Just check the orders. Who had appeared on behalf of the
My
respondents?
apology,
Someone
Lordship.
had prayed.
Yes.
Yes,
It
you
was
had.
supposed to
were-
be 12 years.
Yes.
I'm sorry.
So you had prayed for 3 weeks'
Yes,
time for
for
receiving
item 12.
instructions. 4.
It's supposed to be 12, item 4. Yes.
Item 4 is supposed to be item 12.
Yes, yes.
So you had wrongly mentioned the number, is it?
My apology, Lordship.
Okay, so no one had appeared for item number 4 previously.
No, no.
Yes.
I'm for the petitioner.
Okay, so
Yes, yes.
so the order which was passed in item number 4 shall be passed for item number 12 and a fresh order for item number 4, where impletement application is allowed along with filing of affidavit, additional affidavit by the petitioner. Okay. Anyone appearing for the respondents? Item number 4?
Yes, I'm appearing on behalf of my senior, Mr. Yangarwati.
Okay.
For Union
Miss
Asikire.
Asenkere makes appearance on behalf of her senior, Mr. Yangarwati, learned counsel for the respondents. In view of the above, as prayed for,
18.
this matter may be listed on 18/5/2023.
Normal spike.
My pleasure, Lordship.
Yes.
Lordship, I beg to mention item number 30. I'm here to receive instructions, so Lordship may kindly grant 3 weeks' time to file my counter affidavit.
3-0.
Lordship.
Heard Ms. So-and-so, learned government advocate, who has prayed for time for filing of their counter affidavit since she has yet to receive instructions from the state respondents. Ms.
Medokiki.
Medokiki appears on behalf of,
Petitioner.
okay, the petitioners. List this matter after
3
weeks.
Are you pledged?
Yes, any other mention?
For admission, item number 5.
Yes. What is this about?
I would like to concentrate in the part third matter, Lordship. So this matter may be
Okay.
Passover for the day.
Heard Mr. C.T. Samir, learned senior counsel, who has prayed that this matter may be passed over for today. Mr. So-and-so appears on behalf of the state respondents. List this matter, in view of the above, list this matter after 2 weeks.
For admission, item number 6.
Yes.
May I please, Your Ladyship?
Mhm.
This writ petitions pertains to implementation of PMEGP scheme. The petitioner is a select candidate for PMEGP under Mokchong district. He was selected by the district DIC Mokchong for setting up of stone crushers unit at Ismyong Mokchong town, Mokchong village. However, though he was a select candidate, he was not sanctioned the loan by the respondent number 5, that is the HDFC Bank. May I take your lordship to the annexures, my lord.
Okay.
Annexure page 15, annexure B.
Page 50.
Yes, annexure B to the writ petition.
One five or 50?
15, annexure B, 15.
Yes.
This is the application of the petitioner.
15, annexure
Yes.
B. Yes.
This is the application. And then page number 24. This is the letter from the General Manager, District Industry Center, Mokchung, to the Branch Manager, HDFC Bank. Married. This is letter number so dated 31st July 2017 to the Branch Manager, HDFC Bank, Mokchung. Subject: Bank-wide submission of application and detailed project report of beneficiaries selected under PMEGP 2017-18. Sir, I have the honor to forward herewith the application forms and details project report of 8 numbers selected beneficiaries under PMEGP 2017-18 allocated to your esteemed establishment. The same data has been duly forwarded online in soft copy as per the prescribed procedure. This is for favor of your kind information and necessary action. The next page, 25. This is
Yes.
the list of the beneficiaries who were selected.
Yes.
The name of the petitioner is at serial number 1, Akang Numba Au. And the name of the scheme is Stone Crusher, location is in Sinyong. This was forwarded for consideration. However, the respondent number 5, the next page, page number 26, and actually E. This is the impugned letter. By this impugned letter dated 25th October 2017. Dear Sir, Madam, reference number so and so, thank you for your application for a STFT Bank government-sponsored loan. Your loan application has been considered in line with the bank's internal credit policy, which is based on a combination of financial and related criteria and or statistically determined scores to assess credit eligibility and operating credit process, which include a combination of verifications, credit review reports, and document verifications. We regret to inform you that based on the above, we are unable to approve your loan as your application does not meet the above mentioned internal criteria of the bank. Please be assured that our inability to approve the government-sponsored loan application does not reflect on the credit standing or your financial stability. We will be pleased to provide any other assistance service that you may require. Thanking you once again for so and so, so and so. By this letter, the application of the recommendation of the petitioner was turned down. Thereafter, what happened? Since there were so many other beneficiaries who were selected, but they were not allocated the scheme, the loan. So there were some allegations, the litigations, and then it was the next page, 27. The problems faced by these beneficiaries were addressed by the AKM, which is the apex body of the students. The paper publications is towards the right side and PMEGP, MTLT, and AKM have a leadership for this. Last towards the right side of the button of the top. These are the grievances which were addressed by the AKM and the MTLT. PMEGP, MTLT, and AKM said many eligible youths applied for the Prime Minister's Employment Generation Program, PMEGP, but till date, there were many beneficiaries who have not received the funds under the flagship program of the center. They demanded the DC intervene into the matter and direct the respective banks to dispense the funds at the earliest. Meanwhile, the two organizations affirmed that the issues raised would be pursued till the end. This was the initiative taken by the apex body of these students as well as the youth. Now, in view of the initiative taken by that apex body, some settlement has come. And an understanding has come that they will consider. Now, it was again taken up by the respondents for reconsideration. However, subsequently, again, page number 28, and G. Again, by this impugned letter, they have turned down the application of the petitioner, dated 19/3/2018, to CEO Mokchung, application under PMEGP scheme for the year 2016, 17, and 17, 18. Dear sir, this is with reference to the application the bank has received under the government sponsored scheme. The officials of the bank have interacting with your office for this application. In this regard, to the above, please find the application the branch of the bank has received. And then the name of the petitioner is at serial number 3. Name account number PMEGP, project not feasible, project cost 24.49 lakh, no existing financial banking. This was the reason. And then the last line, the loan application has been processed as per the private sector lending norms formulated by the bank for this government-sponsored scheme. These proposals have been evaluated in detail. The applicants have been made by the bank's representative. The business potentials of the applicants have been also evaluated along with the income generation capacity of the applicants. The Central Risk Team in Mumbai has also done a due diligence. Based on the findings of the credit evaluation process, the bank is of the view that it will not be in a position to fund these proposals. The bank will welcome applications under the government of sponsor scheme. The bank stands to its commitment on meeting its targets on the prior sector and government-sponsored finance schemes. Thereafter, since it was turned down, the petitioner, through his counsel, have submitted a legal notice, but it was not considered, and that's how this writ petition was filed before this honorable court.
Okay.
Now, my ladyship, I'd like to take you to page number 31, annexure I. This is the guideline on Prime Minister's Employment Generating Program, PMEGP. I'll just like to read the scheme and the objective.
Okay.
The scheme. Government of India has approved the introduction of a new credit-linked subsidy program called Prime Minister Employment Generation Program by merging the two schemes that were in operation till 31/3/2008, namely Prime Minister's Yojgar Yojana, BMRY, and Rural Employment Generation Program, REGP, for generation of employment opportunities through establishment of micro enterprises in rural as well as in urban areas. PMEGP will be a central sector scheme to be administered by the Ministry of Micro, Small and Medium Enterprises. The scheme will be implemented by Khadi and Village Industries Commission, (VIC), a statutory organization under the administrative control of the Ministry of MSME as the single nodal agency at the national level. At the state level, the scheme will be implemented through the state KVIC directorates, state Khadi and Village Industries boards, and district industry center and banks. The government subsidy under the scheme will be routed by KVIC through the identified banks for eventual distribution to the beneficiaries, entrepreneurs in their bank accounts. The implementing agencies, namely KVIC, KVIPS, and DICs, will associate reputed non-government organizations, reputed autonomous institutions, self-help groups, National Small Industries Corporation, Udyami Mitras impaneled under Rajiv Gandhi Udyami Mitra Yojana, Panchayati Raj institutions, and other relevant bodies in the implementation of the scheme, especially in the areas of identification of beneficiaries of areas specific viable projects and providing training in entrepreneurship development. Number 2 is the objective. Now, the objective.
Wait, can you explain this? The implementing agencies.
Yes.
Okay. So who is the implementing agencies? The ones which were mentioned before. Okay. District center, whatever.
Yes.
Now they are going to identify.
Now they have already identified
self-help groups.
Yes, and selected the petitioner.
So are you a self-help group?
Yes, I'm a selected candidate.
Candidate as what? As an individual or?
Yes, as an entrepreneur, individual.
Under
and the nodal department.
Self-help groups, national small industries,
yes,
corporation, then UME Mitras and paneled under the Rajiv Gandhi whatever and other relevant bodies. So you come under relevant bodies or what?
Yes,
as an individual. Is it given to private individuals? I'm just curious.
Mine is under entrepreneurship.
Where's the term entrepreneurship mentioned here?
Mine is.
Okay, and providing training
Yes.
in their, and providing training and entrepreneurship development. Okay.
Now this number 2 is the objective.
Hmm.
The objective, number 1, to generate employment opportunity in rural as well as urban areas of the country through setting up of new self-employment ventures project micro enterprises. Number 2, to bring together widely dispersed traditional artisans, rural and urban unemployed youths and give them self-employment opportunities to the extent possible at their place. Number 3, to provide continuous and sustainable employment to a large segment of traditional and prospective artisans and rural and urban unemployed youths in the country, so as to help arrest migration of rural to urban areas, to increase the wage earning capacity of artisans and contribute to increase in the growth rate of rural and urban employment. I am an unemployed educated youth. Being unemployed, I've applied under this scheme, which is a flagship program. Now, though I am a select candidate, the respondents are, till now, they are not giving me the aid as provided by the scheme. The state respondents, instead of taking initiative to make sure that the project is implemented and it's given to full effect too, they are just slying away with the responsibility, saying that this is to do with the bank and the applicants. And then whereas the banks are saying that I do not meet the internal criteria.
So what is the internal
No, what, now
criteria
I'm in the
required?
if I approach this side, they say like it's to do with the bank. Now that this project is a flagship program, it has to be implemented in total. But this nodal department, instead of looking to the grievances faced by the applicants who are the select candidate, just sitting idly. If the one bank is refusing to grant aid, they can always opt for other banks also. But just they're keeping silent. I have nowhere to go. Though I'm a select candidate.
What is this thing? What is the scheme that you have projected? What are you planning to do?
I'm intending to set up a stone crusher unit. That is Annexure B, page number 15. This is my project. Annexure C is the project report, page 16. Page 16. Page 16. So page 16. Annexure C.
And how much are you this thing? What is the cost of your project?
My project cost is 24 lakhs.
Who is funding this project? It's a scheme, but it's a bank who has to.
Yes, who's the sponsor?
And at the interest, the loan, it's a form of a loan, isn't it?
Yes, it's a loan. Only it's a loan.
So what is the interest rate for this?
The
The interest rate, is there any interest?
There's no interest, but there's a subsidy of 35%.
There's no interest and
Yes.
35% is subsidy.
Yes.
Where's that?
Page 32.
Page?
32. Ladies, you got it. Number 3, quantum and nature of financial
So
assistance.
beneficiaries' contribution to the project will be how much? If it's 24 lakhs, your contribution will be
5%.
5%.
Yes, so it will be.
So how much are you supposed to be contributing?
I'm willing to contribute any as per this 5%, provided I'm given the loan.
No.
Question.
So you're depending purely on the loan, is it?
Yes. Since this is a flagship program, they are providing loan to uh, to give sustenance to the educated employees for employment.
Anyways, let's see, we'll hear the other side, the scheme. Yes. So you're saying you were selected. Who had selected you, you say?
The select candidates are at
Who selected you?
the task force
Task force consists of?
under the chairmanship of the deputy commissioner and the nodal department, that is the district industries and commerce department.
Okay, district industries.
Yes.
So you feel that as per the selection made by the task force in
Yes.
toto, it has to be followed by
Yes.
the banks. Okay, we'll hear the other side.
May I please, Your Lordship? My Lord, I'm relying on paragraph 4 of my affidavit in opposition. My Lord, here my submission is, as per the guidelines, the state respondent has conducted the interview and selected the list, and that selected list has been submitted before the HDFC Bank. So, my Lord, in regard to the disbursement of loan, it is purely under the prerogative of the bank. So, whatever role has to play by the state respondent has already done and submitted before the bank. So now the remaining works lies with the bank. So the state
Okay.
has nothing to do with it.
So you're saying that it is as per the prerogative of the bank. When
Yes.
you say the prerogative of the bank, this word, that means you are not the final person to decide. Is it? Do you admit that?
Yes, my lord. Because the selected list, the task force will select the list, the beneficiaries, and that beneficiaries will be submitted before the bank.
So when you say it's a selection, is it a recommendation or when you select, you are recommending the people to be for consideration or what
Yes,
is
yes,
the,
my lord. Yes, my lord.
see, when you say you select, is it, when you send a selection list, is it in a form of a recommendation?
Yes, my lord. Recommendation.
Or it is a recommendation?
Recommendation, yes.
So you're saying that the final decision is in the hands of the bank?
Yes,
Is it
yes, for disbursement of loan. Because the
as
loan.
per your selection?
Yes, and the select list we have already submitted. Your Lordship may kindly see in page 6.
Prerogative, this wording prerogative.
My Lord, see in
That
scheme.
means yes. Where's the scheme?
Scheme para 11 clause E.
Page?
Page.
See,
Page 39, my Lord.
the main issue here is
Page
whether the bank is compelled in toto to give loan as per the selection list or whether the bank has the discretion to again, make a changes or whatever. I think that's the main issue
Yes.
here. So what does the government say? Under
My
what
Lord,
part? Yes.
in clause E.
Clause E,
Yes.
page
Page 39.
of the
Scheme.
petition.
Oh yeah, affidavit in opposition.
That's the main issue here. Yes.
E, clause E. May I read, my
E,
Lord?
yes.
Bank will take their own credit decision on the basis of viability of each project. No collateral security will be insisted upon by the banks in line with the guideline of RBI for projects involving loan up to rupees 10 lakhs in respect of the project cleared by the task force. However,
This is more than 10 lakhs, isn't it? 24
Yes.
lakhs, yes.
However, they will appraise project both technically and economically after ensuring that each project fulfills the criteria of industry, per capita investment, own contribution, rural areas, and negative lease. It is essential that the application cleared by the district task force also fulfill the requirements at that stage itself so as to avoid delay in approval of loans in banks.
So, yes, so the job of the task force in selection is to assist the bank in giving out loans, is it?
Yes,
The
in selecting the
yes, the initial selection
beneficiaries.
is done by you.
Yes, in selecting the beneficiaries,
Okay.
the tax force.
Uh-huh.
They will
Fine,
select the
I got it.
beneficiaries and that list will be submitted before the bank.
And then it is left to the prerogative
Yes,
of
ma'am.
the state bank. That
Yes.
is here.
That is the only
Fine.
submission. Madam.
Yes, now the bank.
This is Lordship. I'm for the private bank respondent number 5 and 6. Madam. The petition, the scheme was rejected as the petitioner has rightly pointed out at page number 26, my lord. I may not
For
go
what
through it again.
reasons? Huh.
The reasons have been cited. 26. Again, I would like to read the page 26, my lord.
26.
My page is of the
writ
writ petition.
Yes.
Yes, madam. Your loan application has been considered. I'm reading it from the third para. The loan application has been considered with the bank's internet credit policy, which is based on a combination of financial and related criteria and a statistically determined scores to assess credit eligibility and operating credit process, which include a combination of verification, credit bureau reports, and document verifications. We regret to inform you that based on the above, we are unable to approve your loan as your application does not meet the above mentioned internal criteria of the bank. Here, my lord, we have already informed it was rejected in 2017, my lord. The petition has come before this court in 2020, more than a delay of 3 years. And my lord, and the rejection was also intimated to the government at page 28 of the petition, citing the reason why it was rejected.
CEO, yes.
CEO, man. Because of the internet policy, the petition doesn't require, it's not matching up with the required policy, man, the internet criteria. And that is the reason why it was rejected. Again, I'll read it out. The loan application process, as per the priority sector lending norms formulated by the banks of these government-sponsored schemes. These proposals have been evaluated in detail. The applicants have met the bank's representative. The business potential of the applicants have also been evaluated along with the income generation capacity of the applicants. The central risk team in Mumbai has also done the due diligence. Based on the finding of the credit evaluation, the bank is of the view that it will not be in a position to fund this proposal, my lord. These are the reasons why it has been. And after the rejection of this letter, there was been a widespread protest in the area. And so again, because the banks was supposed to close, in my affidavit in opposition, the Lordship may peruse my affidavit in opposition. At paragraph 5, I have stated, my lord. And has your Lordship got it?
Wait. Don't rush. Your respondent number 5 and 6.
Yes, my lord. Respondent 5 and 6. My lord, at paragraph 6, my lord, internal page 4. I'll read out.
Wait. Affidavit number.
Affidavit opposition by 5 and 6.
Para
my lord.
5.
Para 6, my lord.
6.
Page 4.
Yes.
Para 6, I'll read out. The Department stated that the rejection of the loan was approached by the PMEGP Association, District Edition, to relook the rejected cases, and there was a demonstration, protest by the members of the PMEGP Association against the rejection with the branch in Mukokchon, and it was closed for 3 days. The branch was allowed to reopen after the assurance to relook the rejected cases. After a proposal was sent to relook the matter the second time, the loan of the petitioner was approved in the way back in 2019. After relooking, after much agitation, the bank has considered to relook the agitation, and the loan of rupees 1,30,000 has been sanctioned as per his internal credit policy. But at page 9, my lord, of my affidavit.
Yes, so an amount of
1,30,000.
1,30,000.
My lord, this is what the bank can
Yes.
give, my lord, based on its assessment and comorbidity. And here, it is a computer-generated print. If your lordship asks me to get the printout of the copy again, the date will be written in today's date, my lord. This scheme, a particular page number 9, my lord. So that is the bank what can offer. Now, my lord, these are the rejection scheme. Now, even my learned friend has pointed out, it is a prerogative of the bank to disburse the loan. At page 39 of the writ petition, where it has been clearly stated, whether your lordship has already gone through it, page 39 of the writ petition. Bank E, para E. It is a recommendation. Task force gives us a recommendation, and the final decision lies with the banks to disburse the amount.
Yes.
I will leave a small amount. Banks will take their own credit decision on the basis of viability of each project. It is our discretion and our prerogative to disburse on whatever we can. The risk assess is also there. And thirdly, whether the writ is maintainable against a private bank. We are a private bank. We are taking our own course of action. We have to take our own decision. We have to take care of our own business. Now, I'll cite some of few decisions, of the Supreme Court, where it has been said that a private bank cannot be implemented of just such scheme. I'll cite some
Okay,
decisions.
wait. You're saying that private banks cannot implement these schemes.
Well,
Then why have they chosen your bank? You're a private bank.
They have
And you have
chosen,
agreed to look into the matter.
My lord, it's not only the private
Is
bank.
it because of some understanding between you and the government, or what? How is it that your bank has been selected? This is a central government
My lord,
scheme.
my lord.
And then you have these government, banks also. Then how is it that your bank has been selected in this matter?
That based on some understanding, that I cannot say, my lord. Someday, if it is viable, we'll definitely sponsor the schemes and loans, my lord. And if I may allow, your
Yes,
lordship may allow
yes.
to. This is mine. 2003 10 SEC 739. Which will be relevant for this case, madam.
Yes, para?
I'll read out para 25, 26, 27, 32, and 33. Well, I'll read out the paragraphs.
Yes.
And if your lordship may come to page para 26. First one, sorry, 25.
This is para 25.
As your lordship got it.
Yes.
Para 25.
Yes.
In view of the
long
provision. Para 25. madam.
Yes.
In view of the provisions indicated above under the Companies Act and the Industrial Development Act, it is submitted that the nature control over the companies is more or less the same degree and nature as the control exercised by the banking companies under the Banking Regulation Act. There is control and supervision over the functioning, working, and conduct of business of the companies. A watchful eye is kept over the interests of the shareholders, the interest of the company itself, as well as over the production of the company, even the interest of the company. Even the managing director can be removed by the central government. There's also the powers as indicated above to take over the management of a company. Such powers are indicated above to take over the management of a company. Such power drastic, nonetheless, they remain regulatory in the nature, in the interest of the industry, the company, the shareholders, and in general interest, since production of goods of the importance is most essential for proper economic growth and stability of the country. Paragraph 26, madam. A company registered under the Companies Act for the purpose of carrying on any trade or business is a private enterprise to earn livelihood and to make profits out of such activities. Banking is also kind of profession and a commercial activity. The primary objective motive behind it can well be said to earn returns and profits. Since time immemorial, such activities have been carried on only by individuals generally. It is a private affair of the company. To the case of a nationalized banks, though the case of a nationalized bank stands on a different footing. There may well as be companies in which a majority of the share capital may be contributed out of the state funds, and in that view of the matter, there may be more participation or dominant participation of the state in managing the affairs of the company. But in the present case, we are concerned with a banking company which has its own resources to raise its fund without any contribution or shareholding by the state. It has its own board of directors elected by shareholders. It works like any other private company in the banking business, having no monopoly status at all. Any company carrying on banking business with a capital of 5 lakhs will become a scheduled bank. All that same, the banking activity as a whole carried out on by various banks undoubtedly has an impact on the effect of the economy of the country in general. Money of the shareholders and the depositors in which such companies carrying.
Okay, you come to the more relevant
My
part for
lord.
this matter. Uh, the
My lord, at para
recent
27, my lord.
27, yes.
Such private companies would normally not be amenable to the writ jurisdiction under Article 226 of the Constitution. But in certain circumstances, a writ may be issued to such private companies or persons as there may be statutes which need to be complied with by all concerned, including private companies. For example, there are certain legislation like Industrial Development Minimum Wages Act, the Factories Act, Isolation from Maintaining Power of Environment, say the Heirs and so Act, my lord. Or statutes.
Okay, for these.
For instance,
under
Madam,
226, huh?
yes,
Then?
madam. For instance, if a private employer dispenses with the services of the employee in violation of the provision contained under so Act, it's in innumerable cases the High Court interfered, it has issued the writ in the above private bodies. There may not be my lord. And the most relevant paragraph, at para 33, my lord, last para. For the discussion held above, in our view, a private company carrying on banking business as Sigil Bank cannot be termed as an institution or a company carrying on any statutory or public duty. A private body or person may be amenable to registration only where it has become necessary to compel such body or association to enforce any statutory obligation or such obligation of public nature casting positive obligation upon it. We didn't find any such conditions are fulfilled in the respect of a private company carrying out a commercial activity to a bank. Merely regulatory provisions to ensure such activity carried on a private body does not work within a discipline and do not confer any such statutes upon the company, nor put on such obligation upon it, which may enforce to issue a writ under Article 226 of the Constitution of India, my lord.
Yes.
And my lord, I will cite one another case, my lord. Two other case, my lord. And it is, the citation is not there, Malad. This has been reported in Civil Appeal number 7441 of 2001 in Supreme Court, Malad, reportable judgment.
Yes. From life law, that's why.
Malad. Malad, if I'm mistaken, Malad, that is my copy, Malad. I'm sorry, Malad.
Okay.
I have marked the paragraphs I have marked it.
Paras?
Para 11, my lord. As the lordship got it. And this is a case where, my lord, the banks were compelled to implement the OTS scheme and a one-time scheme. And here, para 11, my lord, as the lordship got it. The sum and substance of the aforesaid discussion would be that no writ or mandibus can be issued by the High Court in excess of the power under Article 226 of the Constitution of India, directing a financial institution bank to positively grant of OTS to a borrower.
What is OTS?
One-time settlement, my lord.
Okay.
It's scheme, one-time
Okay,
settlement scheme.
okay.
The grant of benefit under the OTS is always subject to the eligibility criteria mentioned under the OTS scheme and the guidelines issued from time to time. If the bank financial institution is of the opinion that the loanee has the capacity to make the payment and or that the bank financial institution is able to recover the entire loan amount even by auctioning the mortgage property, secured property, either from the loanee and or guarantor, the bank would be justified in refusing to grant the benefit under the OTS scheme. Ultimately, such a decision should be left.
These OTS schemes, one-time settlement
My lord.
scheme was made by what? The RBI or the
Well,
central
RBI,
government?
my lord, this is a scheme where if there is a default on the part of the borrower,
So,
they can.
so who made the scheme?
My lord?
Who made the scheme? The scheme.
Uh,
The
there's-
scheme was made by whom?
There's no such scheme, my lord, that's on a paper, my lord. It's a scheme where the bank gives a discretion to the customer, to the loanee, if they want to settle it in one time, my
Yes,
lord.
yes.
This is a discretion of the bank, my lord. I'm just trying to,
Okay.
Commercial is the bank whose amount is involved. It's always presumed that a financial institution shall take a prevalent decision whether to grant a benefit or not under the OTN scheme, having regard to the public interest involved, having regard to the factors which are narrated here even. In view of the above discussion and reasons stated above, we are of the firm opinion the High Court in the present case has materially erred and has exceeded in its jurisdiction in issuing a writ in the mandamus in excess of its power under 236 of the Constitution of India by directing the appellant bank to positively consider grant the benefit of OTS to an original writ petitioner. Here I am referring, my
This
lord,
OTS scheme was formulated by the RBI.
my lord. My lord, any scheme, my lord, my submission is, my lord, this is purely the discretion of the bank to grant the, to disburse the loan. And even it is mentioned in the scheme.
Yes,
And
I got your point.
I will not refer much, my lord, on one,
Yes,
last decision, even though it is not binding upon your lordship, my lord, Kerala High Court, my lord.
High Court.
High Court, my lord, but somehow it will be.
Are the facts similar?
My lord,
Facts are similar. Is it a central government scheme?
my lord, regarding the dispersal of
Loans.
loan, my lord.
You see, let the facts be similar. Some scheme
Yes,
of
my
the
lord.
central government which was not implemented.
Yes, my lord. One less of just in Kerala High Court decision, my lord.
Yes.
My lord, paragraph 9, my lord. Though the learned counsel for the petitioner vehemently argued that the eligibility of the petitioner is purely a matter in tune of the so-and-so scheme, and the bank cannot deny the benefit of the same. It is quite relevant, my lord, to this. There is also scheme where.
Exhibit P5 scheme is what? What scheme
My lord,
is
this
it?
is again, my lord, this matter.
A scheme by the central government, is it? Yes, it
Yes,
is
the
a
MSME
scheme
schemes by the
by
government.
the central
My
government.
lord.
Okay.
Yes, my
CGSSD
lord.
scheme. Yes.
Well, here again, I'll read. Paragraph 9. Though the learned counsel of the petitioner vehemently argued that the eligibility of the petitioner is purely a matter in tune with the so-and-so scheme, and the bank cannot deny the benefit of the same, I am of the view that in order to become eligible for the benefit of the scheme, the petitioner has to fulfill the conditions in the said scheme. There are rival claims as to the eligibility by the petitioner, one, and on one hand, the bank on the other side. Mere interpretation of the provision alone is not sufficient to determine the eligibility of the bank. When the respondent bank, after referring to the objective of the scheme and the provisions contained in the scheme, considered the request of the petitioner with reference to the audited balance sheet of the relevant financial years and the accounts of the petitioners maintained by it, found that the petitioner is not stressed the SMSE and is not eligible for the benefit, after evaluation of the request in accordance with the prudent banking judgment and business discretion, this court, which is not equipped with any such prudence in banking, would not be in a position to either declare the eligibility of the petitioner or direct the bank to allow the request of the petitioner under Article 226 of the Constitution of India. Response: if the petitioner makes any proposal for such restructuring, they will take appropriate decision in accordance with the applicable schemes. The petitioner would be free to avail the same. In view of this matter, the petitioner cannot have any right to insist any direction to the bank to allow his request or grant the benefit of the scheme to him when the competent authorities have found that he is not eligible for the same. And that is my case, my lord. Again, I will sum up, my lord, that the petitioner there is a delay of 3 years, my lord, and there is a scheme, my lord, in the provision of the scheme itself, that it is purely the discretion of the bank to disburse the amount. And finally, my lord, one last. If you, that is my submission on this tribunal.
Yes.
My ladyship, I would like to take your ladyship to page number 39.
Page 29.
39.
39 of your petition.
Of the writ
Yes.
petition.
Yes.
Clause T.
E.
Yes. It has, my learned friends have referred to clause E, but it has to be read with clause D.
D. Okay.
Yes. May I read, my lady? The task force, under the chairmanship of District Magistrate, Deputy Commissioner, Collector, will hold quarterly meeting with the banks at the district level to review the status of the project proposals. Wherever the projects are rejected, shortcomings reasons will be furnished by the concerned banks to the implementing agencies concerned, and the applicants concerned will be requested by the KVIC, KVIBs, DICs to provide additional information documents if required, and the concerned representatives of KVIC, KVIPAs, and DICs will provide assistance to the applicants in the process. Since the bank's representative will also be a member of the task force, it needs to be ensured that maximum number of projects cleared by the task force is sanctioned by the banks. Chairman of the district task force will review the performance of banks and the loan payment recovery status in the quarterly review meetings. So, as per the clause D, it says, since the banks are also a member, they should ensure that the select candidates will have to be accommodated.
Maximum number of projects.
Yes.
Yes.
That is one thing.
Maximum,
Yes, maximum.
but not all.
Not all, but maximum. And then if there are some shortcomings or rejected, the applicants are to be informed to provide, for providing additional information what are the shortcomings. But so far as the respondents are concerned, nothing is such has come. And my learned friend has said that I've approached after a gap of 3 years, but there was negotiations were going on, as well as I filed a legal notice in 20th of in 2020. On 10th of 2020. 9th of September 2020, and I filed my writ petition on 10th of December 2020. So there's no delay. And then, even if there is, but for filing a writ petition
9th
under
September 2020.
yes, September 2020, 9th September,
And then you had filed it on?
10th December
Okay.
2020. And
Yes.
then there is no limitation period prescribed for filing of writ under 226. Now, my ladyship, my learned friend has referred to annexure 2, page number 10 of his affidavit in opposition. At one point of time, they are saying that I don't meet the eligibility criteria. Now they are saying they have already sanctioned me 1,30,000.
Yes. What about that 1 lakh? Have you availed of it? No.
No, I have not received such intimation.
Pardon?
I have not received such intimation.
Okay, so
And
now
then-
you go, is that still viable? It's still, okay.
But the interesting part,
Mhm.
the ladyship with the dates, the date is 21st September 2020.
Okay.
They're saying that they have sanctioned way back in 2019. They are just, this is just to cover up the illegal activities. Annexure 2, page number 10.
Annexure 2.
Page number 10 of the affidavit in opposition. That's the ladyship
Just a
brought it.
sec, just a sec.
Affidavit in opposition of the
Yes,
respondents
yes,
number 5 and
yes,
6.
yes.
Annexure 2, page number 10. They're just making misleading statements.
Okay, so you're saying that this is recent after the
Yes,
case?
that too after filing of the,
Yes.
just before filing of the affidavit in opposition. This is the letter dated 21st September 2020. The letter is addressed to
Yes, 9th was when you issued the legal notice.
Yes.
So on 21st, they have replied to your legal notice, isn't it?
Yes.
Yes, so in their reply, they have informed you that you, a loan of 1 lakh something has been given to you, isn't it?
Yes. See, annexure 1.
Annexure 1,
I
yes.
pardon. Page number 9, Annexure 1. Annexure 1. That is
Yes,
the sanction
yes.
letter. Annexure 1. Page 9. Page 9. The letter dated is 31st March 2022. Here's a lot, ladies and gentlemen. Approval letter dated 31st March 2022. Name of the customer is Akang Number Au, that is the petitioner, and this is so they have sanctioned 1,30,000. Now, I filed my writ petition on 10th December 2020. Whereas they are saying that this sanction has been given way back in 2019. I have not received such approval. And then they filed their affidavit in opposition in the month of April 2022. Just before filing of the affidavit in opposition, 1 month prior to filing, they are alleging that they have issued this. They are saying that they have issued this letter, which I have never received. At one point of time, they said, I'm not eligible. Now they have sanctioned 1,30,000, which I have not received. And then this also recently, after filing of the writ petition, just before filing of their affidavit in opposition, which shows they are just trying to mislead the Honorable Court. Just trying to cover up the illegal actions. The date itself says 31st 2022. And then they're saying that as in the paragraphs, in the affidavit of opposition, in paragraph
it says
6.
they're approved way back in August 2019.
This is a computer-generated print, Mana. If your lordship asks me to get the same printout now, the date will be mentioned of today's date, my lord. It was approved way back. I've stated, and it's still in force. If the petitioner want to avail it, Mana, he is still welcome to do it.
Okay. Yes.
But no such approval was received.
Okay. Fine.
And then, my lord, my ladyship, my prayer is that if the respondent 5 and 6 are so reluctant to grant me loan, the respondents, official respondents, the nodal department, they should take initiative to seek for other state sponsored banks or other banks to give me loan. That is my prayer also, prayer number 5.
Okay.
4 and 5. I've make a mention in my prayer also. If the respondent 5 and 6, they are so reluctant to give me a loan, to grant me a loan, it is the responsibility to look out of the respondents 1 to 3, the state respondents. Since I am a select candidate, it has to be implemented. The project has to be, since it's a flagship program, it has to be. So it is the responsibility to make alternate arrangements so that I'm not being deprived. That is my only prayer.
Yes.
If the respondents 5 and 6, they're reluctant to pay, it is the responsibility of the state respondents to look for the interest of the petitioner. If not, the very purpose of this scheme will be redundant.
Yes, but yes, I've heard your submissions. But people keep preparing schemes, asking for loans and the various things. It's not that their schemes are automatically always approved. Okay, I have heard both the parties. Okay, and the WPC is dismissed since the scheme itself, okay, has mentioned that it is for the bank to select as required. Okay, so you have
What
not
about
been
the
selected,
role of the state respondents?
But yes, and then we will mention that the state government may see that, okay, the scheme is implemented as far as possible, but we cannot give direction as to how it is to be implemented, and we cannot insist that your scheme which you have given has to be in toto followed, okay, because your scheme, you feel your scheme is 100% okay, and the state government, the board who looks at it also feels that, okay, this is quite a good scheme, let's recommend it, okay, then the proper experts, that is the bank, who are at risk, they are the ones giving you the money, okay, they will see whether it's actually viable or not, and it is up to their selection. So in the scheme itself, there's a provision where you can look at the matter again, suggestions can be given, okay? So we will, after dismissing your WPC, it will be with certain suggestions, okay, which can be taken up concerning your scheme. You have a meeting with the banks, whether it can be improved upon, And also, you may notice that 1 lakh so and has also been sanctioned to you, okay, which they say is computer generated. I have no reason to doubt that, okay. And therefore, if you want, you can avail of the loan which is already given to you, 1 lakh something so and so. If you feel that that is too less, then you consult the necessary experts, okay, as to how to improve upon the scheme, because within the scheme itself, what you have just read, okay, that clause D, also, no, the one which he read, D, before E, okay, D, it says that there are certain schemes which need to be improved upon, which in the consultation with the bank can be done. So you avail of that, see how can you get the 24 lakhs, maybe there's something missing in your scheme, though approved. Okay, so I'll rewrite the full order judgment. Okay.
What some
And it's
protection should be given
disposed.
to the petitioner?
No, madam,
What
at least
protection? Disposed, it is disposed. Okay,
Well, one-
on those terms, yes.
The one thing, if your lordship has private banks cannot be forced to disburse a loan, my lord. It will are based on.
I've heard your distinct
My lord.
submissions. Okay, order will be, it's a this thing orally disposed. Okay, but full text will be available. Yes.
For admission, item number 13.
Yes, 13. Counter affidavit in opposition to be filed by the government advocate.
Yes, in this case, my lord, my ladyship, I have instructions to appear for the
You're appearing for the,
state respondents.
okay, state
But
respondents.
going through the writ petition, it seems like the filing of the affidavit in opposition won't be required because the prayer is very limited. They are saying
Okay.
just to consider the representation of the petitioner within that time by a speaking order. If a direction can be issued in that line,
Okay, what is your representation?
For payment of salary, Your Lordship. Your Lordship, the brief facts of the case is that the petitioner in this case, he was a police constable and he was arrested under special case NDPS and was placed under suspension. But in the meantime, the petitioner has filed a criminal leave petition before this honorable court for quashing of the FIR and consequential criminal proceedings. And this honorable court was pleased to allow the criminal leave petition. So thereafter, he was reinstated in the service without payment of back wages, Your Lordship. So the petitioner is before this honorable court. He has made a representation, but it was not considered so.
Okay. So it is limited to only
yes, disposal of
Yes,
the
yes.
disposal of the representation made by you dated?
26 August 2022.
Okay.
Yes, Your Lordship. My representation is in
Then
excerpt.
we'll pass the necessary orders. Okay, heard Miss
Viteri.
V. Terrin, learned counsel for the petitioner, along with Mr.
And Longkumar, my lady.
N. Lokumar, learned government advocate.
Not
for
government, but as engaged lawyer.
Okay, learned counsel for the state respondents.
Yes.
Okay. Miss V. Tere, learned counsel for the petitioner, mentions that this application filed under Article 226 of the Constitution of India for issuance of the appropriate writ against the respondents is
More particularly, respondent number 3.
against, okay, more particularly respondent number 3 is for the payment of back wages.
Yes, Your Lordship. During the period he was suspended.
During the period he was suspended.
Till his reinstatement.
Okay, he was till his reinstatement, since he was working as a constable. Okay, this is 8th NAP Battalion
Yes, Your
at
Lordship.
Naltokwa Zuniboto. Full stop, okay. The petitioner was arrested on 10/4/2020 under Section 22 NDPS Act and placed under suspension with effect from 13/4/2020. Full stop. Subsequently, vide order dated 22/3/2022 passed by, where's the order? Annexure?
11,
Page?
54. 54.
His suspension order, Your Lordship. Annexure 4, page 20.
Reinstatement, his reinstatement order.
Page 54.
Page 54.
Yes. That is the type copy.
Passed by the commandant of 8th NAP Battalion, Neltokwa Zeniboto. The petitioner was reinstated. Now, here it says that in the order dated 22nd March 2022, are we on the same page? Yes. That period of suspension shall be treated as not on duty. Okay, so against this order, you have been reinstated here, so you're praying for black wages.
Yes, Your Lordship.
Okay, reinstated. Okay, where he was reinstated on humanitarian grounds. Oh, full stop. Okay. In view of this order, the petitioner had made a representation dated 26/08/2022 before the Director General of Police, Kohima, Nagaland, praying for payment of back wages during the period of suspension. The prayer, full stop, the prayer of the petitioner is limited to the consideration of the representation dated 26/08/2022. Full stop. Mr. So-and-so, learned counsel for the respondent, submits that since the prayer of the petitioner is limited to the consideration of the representation made by the petitioner dated 26/08/2022, he has no objection to the prayer made. In view of the above, this court finds it fit to grant the prayer made by the petitioner in the writ petition, and the state respondents are directed to consider the representation made by the petitioner dated 26/08/2022, praying for payment of back wages during the period of his suspension, Wait, let me see a copy of the representation page.
Page number 55, Annexure 12.
Page 55.
Mm. Which was withheld during his suspension period. Your petition does not mention the dates, is it? On his reinstatement, with effect from 22/03/2022. The state respondents shall dispose of the said representation with a speaking order within 3 weeks.
My lord, let it be.
What? Within 4 weeks?
Yes.
Within 4 weeks from the date of receiving a certified copy of this order. Accordingly, WPC number 233 of 2022 stands disposed.
Highly obliged, Your Lordship.
Yes.
May please, Your Lordship, in the item number 6, my lord, my name is not there in the cause list. But I have signed my vocal number. My name may be reflected, my lord.
Okay.
M. Smith, my lord, for
M. Smith.
for respond number 5 and 6. 4, 5.
Okay. Item number 6, reflect the name Mr. M. Smith, Learned Counsel for respondents number 4 and 5.
Yes, 5 and 6.
If they are registered with the CIS.
Okay. Okay, we'll mention that. Now, the reason why your name was not reflected in the cost list to us, because you are required to be registered with the CIS.
My lord.
Okay, which
That
is maintained by
yes,
this
we'll-
High
my
Court. So
lord.
if you're going to appear for any other case,
Please, I'll do
make
that,
sure
my
that
lord.
that's done. Yes.
Obliged.
Yes, yes, yes.
For admission, item number 35.
Yes, the item which is to be continued, part heard. So in the last court date, we had heard the submissions made by the state respondents also, but citations.
Lordship.
Is it left
Lordship.
at that stage?
Lordship, I have to make some 2-3 submission, Lordship.
Okay.
Final
Continue.
conclusion.
Yes.
Yes, Lordship. May I please, the Lordship? Lordship, in order to refresh my memory, Lordship, I would like to make a brief submission, Lordship.
Yes.
Here, the petitioner prayer is before the dishonorable court is challenging the impugned notification dated 22/12/2022. That is the revocation notification, Lordship. And they have filed the instant petition challenging the revocation notification against the release order, releasing of respondent number 3 from the service under the Nagaland Retirement for Public Employment Second Amendment Act 2009 under Rule Section 3(1) of the rule of the of the Act. However, Lordship, here is the case where error and mistake has been committed by the state respondent, Lordship. Here is a case where it is not about the alteration, nor about the gather or emolument. It is about the wrong committed by the state respondent to make it right, Lordship. Here, Lordship, in the writ petition, Lordship, the petitioner has categorically stated and make a false submission and false allegation against the uh, state respondent, stating that, Lordship, that the earlier respondent number 3, private respondent number 3, has submitted his resignation letter, his representation for revocation, Lordship. But however, Lordship, my humble, respectful submission before the Lordship is that there is no record to show that the representation was submitted by the respondent number 3 and that was declined or rejected by the state respondent. Nowhere there is such record that representation was submitted by the respondent number 3 and that was declined and rejected by the state respondent. The petitioner, they have categorically stated that earlier R3 submitted the representation. R3, he submitted the representation and that was declined by the state respondent. But after going through the records and after going through all the records, nowhere it is seen that earlier he submitted the representation and that was rejected by the state respondent. Lordship,
You're for the thing, state respondent.
for the state respondent, Lordship.
So,
Lordship, here now the apprehension of the state of the petitioner is that once respondent this revocation, if this revocation order notification is not stayed, then the apprehension of the petitioner is that he will be the R3 will be the next ENC, which is like ENC, Engineer in Chief, which is lying vacant, Lordship. As of now, Lordship, the third senior most chief engineer is holding the current charge, additional charge of ENC for a time being, Lordship, because of this litigation, because of this instant case, Lordship. Now, however, Lordship, our submission, the state respondent has categorically stated that, yes, for the post of ENC, it has to constitute a DPC in order to promote, in order to appoint for the post of ENC, that is Engineer in Chief, it has to constitute a DPC, Lordship. And Lordship, fourthly, Lordship, here the petitioner is challenging the notification of the appointment of the incumbent, Lordship. Notification was issued, appointment notification of the respondent number 3 as well as the petitioner along with 3 others. They were appointed through NPC, Lordship. They appear for the NPC, and from the NPC, Lordship, their names were recommended for the post of assistant engineer. Lordship, here, the notification that was issued on 17/4/1989, Lordship, that notification was issued with effect from 8/3/1989. In the said notification, it clearly stated that with effect from 8/3/1989. That is to recon. That is the date where the NPC recommended the name of the private respondent as well as the petitioner, Lordship. And that is solely for the purpose of seniority. That is solely for the purpose of seniority. Lordship, if we
which
go...
is that I don't think disputed by the petitioner. Seniority is not an issue here.
Here, the seniority is not the issue. But what I would like to place before your Lordship is that here the petitioner is saying that since he was appointed by the order, by the notification that is 17/3/1989, then in that view of the matter, since it has been reckoned with effect from 8/3/1989, then he, as per the submission, the petitioner should have been above the private respondent. That is the stand of the that is the submission advanced by the petitioner. But here what we are saying is, since it's a logic things, Lordship, since at that point of time, at that point of time they were not born in a gather, they were not being appointed as assistant engineer. Only by the notification dated 17/4/1989, they were only born in the gather only on 17/4/1989. So it is a logical thing, Lordship. When the notification, appointment notification was issued by the state government only on 17/4/1989, on the same date, the private respondent has submitted his joining report, Lordship. He took over the charge as assistant engineer on that very day, Lordship. So, Accountant General, they started preparing the pay slip and everything on 18/4/1989, Lordship. However, in this instant petition, Lordship, that is out of record, Lordship. But the petitioner has never met Accountant General as a party to it, Lordship. So, Lordship, out of record, Lordship. However, the petitioner, since notification was issued only on 17/4/1989, the petitioner must have joined the service after that only. So maybe 18, 19, that out of record, but
Yes.
So if we go by the submission of the petitioner is saying that since it is with effect from 8/3/1989, he should be senior most. Then in that view of the matter, Lordship, the merit list, it has no meaning, Lordship. Merit list is solely for the purpose, the appointment notification order that was issued is as per the merit list. So our petitioner is below the R3, Lordship.
So seniority is not disputed, I don't think. I think it is the age of supernature distinct pension, retirement.
Yes, Lordship. So, Lordship,
They are saying that he was appointed in 1987 when he
Lordship.
first joined the government service.
Lordship.
Okay, while your stand is that there was a break of service,
Lordship.
and then his service has to be counted from 1989.
Lordship.
So come to that point, yes.
Yes, Lordship. Earlier, R3, he was appointed on contract basis. And that was extended
Contractor.
from time to time. And that too in the post of junior engineer, not to assistant. The
Yes.
next post is to that of assistant engineer / SDO. Earlier, R3, he was appointed as J, and his service was extended from time to time, and that too on the contract. And I have annexed in my affidavit also regarding the contract appointment. However, Lordship, he sit for the NPC, and NPC has recommended R3 on 8/3/1989, Lordship.
Yes.
And thereafter, Lordship, there and moreover, Lordship, and the state respondent, which is at page 27, Annex E of my rejoinder affidavit, rejoinder affidavit 1 and 2, Lordship, dated 13/3/89. The state respondent has intimated to the R3 offering letter for the post of assistant engineer and SDO, and that was accepted, and which was followed by the appointment notification.
Yes.
And thereafter it was followed by the charge, taking of charge, and followed by the preparation of the pay slip and salary slip by the AG. Lordship, therefore, Lordship, here is a case where there is a break of 37 days. If you go by the records, Lordship.
Yes, I think I have noted your points here
Yes, Lordship.
previously. Yes.
Lordship.
You said 37 days break.
Yes, Lordship,
Oh.
there is 37
And
break.
payslip was issued only from 18/4/2000, 1990, 89,
Yes,
1989.
Lordship.
Yes, so
Lordship.
I think I have noted down all that.
Yes, Lordship. And Lordship, here we have made a categorically statement, Lordship. There was a series of communication between the department as well as the government regarding regarding the the order, resignation order, the acceptance of the resignation letter tendered by respondent number 3.
You're saying there's no communication.
There was a series of communication.
Okay, there was series of
Communication
okay,
between the
series of
department,
okay.
department and the government with regard to the acceptance, the resignation tendered by the R3 regarding the acceptance order. But we have categorically stated that even the department has categorically stated that there is no record as such. There is resignation is letter is there, but however the government officially the official acceptance letter was not there.
Yes.
Because of the shifting of SC office, Lordship.
Oh.
They could not trace out the record. But the department has also categorically stated that civil list as on 1st January 2020 and as well as the PIMS and office memorandum, which clearly state that this is the authenticate record, Lordship. And there is consistent in that, Lordship. Even in the civil list as well as in the PIMS, it clearly states that date of joining is 03 with effect from 08/03/1989. And there is a consistency. I will come to that, Lordship. So, here the petitioner has also annexed office memorandum counting of contract and ad hoc. But however, Lordship, that I have also, the state government has also annexed that office memorandum. That office memorandum clearly state that, Lordship. Counting of contract ad hoc work charge substitute period for retirement purpose, which clearly state that, Lordship.
Page, where's that page?
That earlier I have made my submission, Lordship. Lordship, that would be in my rejoinder affidavit, respondent number 1 and 2, Lordship. Respondent number 1 and 2, Lordship. Page 33.
Affidavit, just a second. Affidavit in opposition, affidavit in reply.
Rejoinder affidavit for and on behalf of respondent 1 and 2, respectively, to affidavit in reply filed by the petitioner. Lordship, this is a file in the month of April.
Rejoinder affidavit on behalf of respondents number 1 and 2. Yes.
Lordship.
Index 9. Huh.
Page 33. Page 33. 6. Para 6, Lordship. 6. This is the office memorandum, Lordship. Office memorandum dated 31st August 2017. That even the petitioner, they have annexed this office memorandum, Lordship.
Yes, what does it say?
6.
Page 33.
Page 33.
Hmm.
May I read, Lordship?
Yes.
Here it's stated that now, therefore, it has been decided that the period of service rendered on ad hoc contract work charge substitute basis which is followed by regularization or regular appointment without break. Here it says without break. Or, more important, Lordship, or any gap in service except resignation, Lordship, shall be treated as public under the Nagaland Retirement from Public Employment Second Amendment Act 2009, Lordship. Here is a case, Lordship, where the respondent number 3 has tendered his resignation on 9/3/1989. Though there is no record for acceptance
yes.
order, Lordship. But from the civil list as on 1st January 2020 and from the PIMS, it has clearly shown and clearly indicated that the R3 has entered into the service on 8/3/1989.
Okay.
And
Can
there
you-
is a
Can you
consistent.
take me to this 1st January to 2020?
Lordship, that I have annexed in my affidavit. But instead of that, Lordship, I would like to, since this is the clear picture, this is the
Okay.
clear one.
Not the PIMS, but the list 2020.
Office memorandum and
1st, 2020, where is it mentioned? Any affidavit in opposition?
yes, Lordship. Affidavit in opposition, Lordship. I have annexed in my affidavit in opposition. But however, this copy is clear. Though I have annexed in my
Wait. Okay, in the affidavit in opposition,
Lordship.
state civil list. This is
Lordship,
what you're
Lordship.
mentioning. Okay.
And
No
page
need.
21.
Page 22, 21.
starting from page 21.
Yes.
Page 21 is the employment code. On the left, right-hand side, Lordship, it's stated that
Okay,
8/3.
okay. Date of first entry into government service.
Lordship.
Okay, 08/03/1980.
Yes, Lordship.
Yes.
And supernation, 31/03/2024. Lordship.
Okay.
And moreover, civil list, page 22. As on 1st
Page 22 is the civil list.
Lordship.
Yes, 1st January, yes.
Lordship. And the petitioner name appears as serial number 10. And the petitioner R3 10 and petitioner 11. Here also, Lordship, date of first entry into government service. It's 8/3/1989.
Yes.
So, Lordship, here is a consistency, Lordship. So this is the authenticate record, Lordship. So the state government has accepted his resignation, and accordingly, Lordship, it was recorded in the state civil list, as well as it was recorded in the PIMS regarding his date of entry and his supernation, Lordship.
Fine.
And Lordship, on the last occasion, Lordship, I have categorically stated with regard to the withdrawal of the salary.
Yes.
Salary
You
statement.
mentioned,
And Lordship, from there also, Lordship, it is crystal clear, Lordship. Even the petitioner, here the petitioner is also not disputed, saying that the R3 has drawn his salary starting from April, which is
89.
Lordship,
Yes.
starting from 18 April to May, which is rupees 1,092. And as far as May is concerned, Lordship, R3, the salary that R3 received was 2,626, Lordship. That is a
Yes.
whole salary, Lordship.
Yes, yes.
So on the last occasion, so even the petitioner is not disputed, Lordship. Here the petitioner is also saying that categorically stated in the affidavit stating that, yes, he has not withdrawn for the month of March, Lordship. So which clearly indicate that there is a break in service, Lordship.
Yes.
So, Lordship, PNR, from the PNR, they have met a category of, they have clearly stated that they are precluded by the principle of estoppel. And Lordship is well aware, Lordship may appreciate, principle of estoppel is a rule which prevents a person from taking up inconsistent position from what has pleaded or asserted earlier, Lordship. And to that, Lordship, now I would like Lordship to pay your Lordship attention to page 57 of my rejoinder affidavit, Lordship. Of my rejoinder affidavit, page 57. I will only take you to the relevant paragraph, Lordship.
When was it filed?
April, Lordship, on the month of April.
Affidavit in the word rejoinder affidavit.
Lordship.
Okay.
Page 57, Lordship. Why the government is precluded by the principle of estoppel.
Yes.
57. Roman 7, Lordship. It has to be Roman 7, Lordship. This is a type copy. Chart is there, 57. Page 57. This is the type copy. This is the type copy of the.
Yes.
Here is the case where the direct recruit SDO, assistant engineer, in Civil Rule 120 of 1993. Has filed the instant petition, Lordship. And here, this is the affidavit in opposition filed by the state respondent. Filed by the state respondent in the earlier case, Lordship. So basing on this, Lordship, PNR has made an observation, Lordship. Page 57, Lordship. Page 57, this is the type copy. May I read, Lordship?
Yes.
5, it will be Roman 5, 6, 7. It will be 7, Lordship, not 6. It will be 7, Lordship. I am allowed to make certain corrections. 7. May I read, Lordship?
Yes.
That some of the petitioners are undisputedly senior to the respondent number 3, and some of them are junior to respondent number 3. Their seniority position as maintained by the department at present is as under, Lordship. Now, Lordship, in the chart, serial number 21.
Yes.
Lordship, I have got it.
Yes.
Lordship, serial number 21 is the present respondent number 3. Here, appointment as SDO or assistant engineer. So, appointment as SDO is 8/3/1989.
That's
And
not disputed, yes.
yes, and serial number 22, this is the present petitioner. Appointment as SDO 8/3/1989, Lordship.
Serial number
22,
22, yes.
Lordship.
below him.
This is the
Yes,
present
yes,
petitioner,
yes.
Lordship. So this is the position, Lordship. And basing on this, Lordship, now the state government is precluded. Their state is precluded by the principle of estoppel, Lordship. We cannot make a difference then. Here in this Civil Rule 120 of 1993, we have categorically stated that they have joined the service on 8/3/1989. Now we cannot say that no, R3, since initially he was serving as a JE on contract basis, so his appointment, it will be reckoned from the date of his initial appointment. Now we cannot take a different stand, Lordship. That is my whole,
Okay.
whole issue, Lordship. Now, Lordship, I will also like to rely on some of the Supreme Court judgment, Lordship. Lordship.
Yes.
This is 1981, SCC Online, Bombay 36, AIR 1982.
Yes.
And here,
Para?
principle of estoppel. Principle of estoppel was discussed. Relevant paragraph 9, Lordship.
Yes.
May I read, Lordship?
Yes.
Another case cited by Mr. Junglamwala was Dexter Limited versus Hillcrest Oil Company, Bradford Limited, reported in 1926, 1 KB 348. In that case, the umpire made 3 awards on different footings and then started a special case, leaving the court to decide which award was right. The amounts in the first and the second award, which were in favor of the appellant, were different. The amount in the second award being higher than the one in the first award, the third award was against the appellant. In that case, the court decided that the first award was the correct award. The appellant in whose favor the said first award was decided demanded the amount and obtained payment, and thereafter appealed for the decision of the judge, contending that the second award was the right one. It was held in that case that having demanded and accepted payment under the first award, the appellant was precluded from contending that it was wrong. This case was decided on the same basis as the decision in the earlier cases, and also on the basis that by accepting payment under the first award, the appellant had precluded the respondent from challenging the second award and contending that the third award was the correct award, Lordship. Next page, Lordship. 10, Lordship. Accordingly, in my view, the principle of estoppel applies and the petition is not maintainable. Lordship.
Yes.
And secondly, Lordship, this is Supreme Court of India.
Para?
Para 15, starting from para 15, Lordship. May I read, Lordship?
Yes.
Estoppel is a rule of evidence, and the general rule is enacted in Section 115 of the Indian Evidence Act, 1872, in short, Evidence Act, which lays down that when one person has by his declaration, act, or omission caused or permitted another person to believe a thing to be true and to act upon that belief, neither he nor his representation shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. 16. Estoppel is when one is concluded and forbidden in law to speak against his own act and deed, yea, though it be to say the truth. Cited in so and so. So there is said to be an estoppel where a party is not allowed to say that a certain statement of fact is untrue. Whether in reality it is to be true or not, estoppel or conclusion as it is frequently called by the older authorities may therefore be defined as a disability whereby a party is precluded from alleging or proving in legal proceeding that a fact is otherwise than it has been made to appear by the matter giving rise to the disability. Halsberg so and so, the rules on the subject is thus laid down by the Lords then men in so and so, but the rule is clear that where one by his words or conduct willfully causes another to believe the existence of certain state of things and induces him to act to that belief so as to alter his own previous position, the former is concluded from averring against the latter at different states of things as existing at the same time. The whole doctrine of estoppel of this kind, which is fictitious statement.
Yes, I've got your point. So you're
Lord.
saying that now we have said that his date of appointment is 89. Now we cannot revert to and say it's 87. That's your main
Lordship,
point,
Lordship,
isn't it?
and
Yes.
Lordship on the natural justice, Lordship.
Yes.
I will natural justice 2018
Yes.
SCC online, which relevant. I will only read the relevant portion, Lordship. That is paragraph 16.
Yes.
Paragraph 16. Married Lordship. Keeping in view the law laid down by the apex court as discussed above, if a mistake was committed by the authority and on its detection, the same was rectified by revision of the result. This court is of the considered view that no illegality or irregularity has been committed by the authority so as to exercise the extraordinary jurisdiction of the court by invoking Article 226 of the Constitution of India. In view of the above position, the writ application has no merit and the same is hereby dismissed, no order as to the cause. Lordship. In our present case, and as Supreme Court has cited, Lordship, this is very much relevant, Lordship. And Lordship, the petitioner herein has invoked Nagaland as invoked Nagaland Rules of Executive Business 2020, Rule 8, 10, 1, and 6. But here in this case, here they are saying that it is an alteration, Lordship. Yes, in case it is to do with alteration, Lordship, this section, this rule will very much come into play, Lordship.
Yes.
But here is a case. Here is a case where the mistake has been committed by the state respondent, Lordship. So but it was only found out after receiving of the representation by the respondent number 3. And then after receiving of the representation, Lordship, it went through the consultation to the Law and Justice Department, and thereafter to the PNR. And PNR has made an observation, Lordship, basing on by applying the principle of estoppel, Lordship. So, Lordship, here, this Rule 10, Rule 8, and Rule 10, had it been the alteration, Lordship, this will very much come into
Rule
play.
of
Rule 8, 10.1
Yes.
and 6.
What is the
Lordship.
name of the rule? Nagaland rule of?
Nagaland Rules of Executive Business 2020, Lordship.
Okay.
Here, the petitioner is saying that,
Do we have that?
Lordship, rules of
I don't think that is that. Hmm.
Rule 8,
Hmm.
Rule 10.1, and 6 Roman 1, Lordship.
Hmm.
Here the petitioner is saying that it has to place before the cabinet, and that in consultation with the finance department. Yes, had it been the alteration, Lordship, definitely it has to route through the cabinet in consultation with the finance. But here is a case where the error and mistake has been
Okay, so
committed.
you're saying it is a mistake.
Lordship.
Mistake was previously in counting the seniority, 1987 was taken, isn't it?
Lordship.
Seniority, huh?
Lordship.
Yes.
But Lordship, even the office memorandum also says that accept resignation, Lordship.
Mm-hmm.
So the petitioner counsel, senior counsel, they were relying on series of rulings. But that does not help the case of the petitioner. Why? Because there is a case where there is a continuity in service. There is no break in service. And moreover, Lordship, the petitioner also relying on some of the series of this employee who were initially appointed on contract and then they were followed by retirement, Lordship. But that was, in that case, it is a case where they were initially appointed, which was followed by regularization. And in those cases, in those order, Lordship, there was no break in service, Lordship. And then, Lordship, they were initially appointed as, though it is an ad hoc contract, Lordship, they were all appointed on assistant engineer SDO, Lordship. So they continued in service, Lordship, followed by regularization and thereafter retirement, Lordship. But here is a case, Lordship, where the respondent number 3, initially he was appointed on contract basis as that also of JE, Lordship, junior engineer, Lordship. Thereafter, he sit for the NPSC. NPSC has recommended his name, followed by the acceptance from the state respondent. And thereafter, notification was issued on 17/4/1989, Lordship. So, Lordship may appreciate, and Lordship is well aware that in a welfare state, Lordship, state being a nodal employer, Lordship, it is the state, Lordship, where mistake has been committed. It is our duty. It is our bounded duty in a welfare state. It is our bounded duty to make things right, Lordship. So, Lordship, here, no illegality or arbitrary has been committed by the state respondent, Lordship. So, Lordship, the instant petition is liable to be dismissed, Lordship. I rest my case, Lordship.
Yes. Yes, respondent number 3.
I'm appearing for respondent number 3, Lordship.
Yes.
In the past, there has been series of litigation with regard to the Retirement from Public Employment Act, but all those cases were on different facts. So I would like to cite a brief background of the Retirement Act. In view of the acute employment problem in the state, the state legislature has enacted the law
Hmm.
called the Nagaland Retirement from Public Employment Act 1991
Hmm.
initially, fixing the length of service of 33 years and 57 years of age on superannuation.
The first act was
91.
1991.
Nagaland
Okay.
Retirement from Public Employment Act
Hmm.
1991,
Hmm.
whereby the length of service
Hmm.
for retirement was fixed at 33 years
Hmm.
and
Age?
was 57 years.
Hmm.
This came to be challenged
Hmm.
by the Nagaland Confederation of All Nagaland Services Association, KANSIA in short.
Hmm.
And then this Honorable Court has quashed the fixing of 33 years of length of service.
Okay. Hmm.
However, back wages were denied on the persons who have retired paying on the Act. Therefore, writ appeal was referred by the KANSIA,
Hmm.
and that was allowed, and consequential benefits were also given.
Hmm.
Thereafter, for the second time,
Hmm.
the Act came to be amended in 2007, where the retirement age has been enhanced to 60 years.
Hmm.
Nobody challenged this. After about 2 years, this Act came to be amended as the Second Amendment Act,
Hmm.
where the retirement age of 35 years, the length of service was fixed at the age of 35 years, and 60 years it was maintained as before on superannuation. This second enactment came to be challenged by a group of Senior Government Employees Association.
The second enactment was dated?
It was in the second
Amendment
enactment
Act.
was, just a minute, Lord. It came into force.
2007 Act was amended, isn't it?
Yes.
And the Amendment Act is 2000?
Second Amendment Act 2009 is the
Nine.
12 August 2009.
Okay.
This enactment came to be challenged by Nagaland Government, Nagaland Senior
whatever.
Government Employees Welfare Association.
Hmm.
The Nagaland Senior Government Employees Welfare Association.
Yes.
But the writ petition came to be dismissed.
Hmm.
Now, it went to the Apex Court,
Hmm.
and then in the Apex Court has upheld the decision of the Gauhati High Court.
Okay, the dismissal.
Yes.
Yes.
The
order.
issue
Hmm.
in that case was
Hmm.
fixing 35 years of retirement age, length of 35
Service.
years for retirement is unreasonable, arbitrary, and violative of Article 14 and 16 of the Constitution of India. That was the issue. 60 years they have not challenged, but fixing 35 years of length of service was challenged. Now, I am referring this case only to show that what was the issue in this particular case. Because of the fact that in all the cases with regard to the retirement age, retirement cases, this citation, this ruling has been referred by different courts.
Okay. Hmm.
However, it was not relevant. I do not know how it was relied on. Maybe during the course of argument, the Council for the State used to refer this case, rely on this case.
Okay, 35 years.
Yes, which has nothing to do with regard to the counting up 35 years of service, from which part of the service should be included, which part of the service should not be included.
Okay, this is
That
not
is the
mentioned
issue in
here.
this.
Okay, this is not mentioned in this judgment. It only says 35 years.
Yes.
Okay.
So I will refer to paragraph 17 of the judgment. I'm just trying to show what was the
Yes.
issue in that case.
Yes.
Paragraph 17, Lordship Mechanic.
Yes.
Yes. Made challenge to the Second Amendment Act 2009. The Appellant Association challenged the constitutional validity of the Second Amendment Act 2009 being arbitrary, irrational, ultra-vires, and violative of Article 14, 16, and 21 of the Constitution of India and legality of Office Memorandum 27, 2009 by filing a writ petition before the Gauhati High Court. The association prayed that the Second Amendment Act 2009 be quashed to the extent it has introduced 35 years service as one of the conditions for retirement of government employees, and direction be issued to the state to superannuate its employee only on attaining the prescribed age of 60. The association also prayed for quashing OM dated 27, 2009. And again, kindly come to paragraph 31. I'm just taking your lordship to show what was the issue in that case. Paragraph 31, has your lordship got it?
Yes.
On the contention outlined above, the question that arises for consideration is whether the imbued provisions that prescribes retiring the persons from public employment in the state of Nagaland on completion of 35 years service from the date of joining or until attaining age of 60 years, whichever is earlier, is arbitrary, irrational, and violative of Article 14 and 16 of the Constitution of India. This was the sole issue. However, in the subsequent proceedings before the Honorable High Court, before this court, this judgment has been relied upon, which was something to do with regard to the object of passing the act in fixing 35 years of service, whether it is legal or illegal. That was the only issue. Whereas, in those cases which were decided, which my learned friend has also referred few cases, and the present case, is with regard to how the 35 years of length of service is to be counted, computed,
Yes.
from which date, which part of the service should be included,
Yes.
which part of the service should not be included. That
From
is the issue.
1987 or 1989.
Exactly,
I think that's the
Lordship.
main issue. Yes.
Yes. 1987 to 8th of March 1989 was a contract service, and 17/4/1989, that is the date of appointment, and on the next day, the P slip has been issued by the Accountant General on 18th of April 1989. From that date, the respondent number 3 started getting the pay.
Okay,
Now-
just a question. Previous to 8/4/1989, he was serving as the JE.
Correct,
Okay.
Lordship.
From where was he getting his pay?
Pay
As a
from the
JE?
department, from the department.
Okay.
From
So
the date of
Accountant
appointment.
General does not keep a record?
Yes, I'll come to that, Lordship, but for a moment, kindly come to the act. What the act says, we have to understand first what is meant by public employment. Because
Okay.
the Indian
Act,
order,
what act? Which act?
it's there in the affidavit in opposition.
Okay, wait, let me come to your affidavit.
Yes, page 35. Affidavit in opposition of respondent number 3. This is very important because the issue involved in this present case is
Yes.
I have been prematurely made to retire from service. That has been subsequently revoked, which
Yes.
the writ petitioner has challenged that as arbitrary and illegal. Therefore, what the act says, what is the definition of public employment then? Since a person has to be retired under the provisions of the Act by invoking Section 3 of the Act, that on completion of either 35 years or on completion of 60 years, a person can be retired from public employment. Therefore, it is necessary to understand what is the definition of public employment. What service can be included under the definition of public employment? What service cannot be included under the definition of public employment? So kindly come to page 35, section 2, clause 1. It talks about what is meant by public employment. This is the fundamental
Yes.
of our case. Section 2, clause 1. May I read, Lordship? This is the definition of public employment. Public employment means appointment to any pensionable state public service or post, connection with the affairs of the state of Nagaland and the Nagaland Legislative Assembly, and includes any appointment under the Government of India, any other state government, central or state public sector undertaking, and local authority held by persons prior to their absorption under the public service of the state of Nagaland and the Nagaland Legislative Assembly, which counts for the purpose of pension. And then under Section 3, Clause 1, a person can be retired, 1 and 2. Now we are concerned with Section 2, Clause 1, about the definition of public employment. Lordship has just said two things are very, very important here. That is, the service, appointment to any pensionable public service or post. That is one. And the last one is which counts for the purpose of pension. Therefore, in order to attract the definition of public employment, the service has to be a pensionable service, and the service has to be count for pension. And Lordship may kindly take note of one aspect. This Act have not defined what is pensionable service. Act under Section 2, it is clearly mentioned that the appointment should be pensionable service and it should count for pension. So we are to understand what is a pensionable service and what type of service can be counted for the purpose of pension.
Yes.
For a pensionable service, Lordship, to treat a service as pensionable service, the basic fundamental principle of the pension rule is there should be no break in the service. In other words, the service has to be continuous and there should be no interruption in the service. And if there is any interruption in the service, then such service cannot be treated as a pensionable service.
Okay.
And for the state of Nagaland, Lordship, state has adopted CCS pension rules 1972. It is not disputed that pension rules is not applicable. It is applicable, and the state government has adopted the pension rules so far as regulation of pensions and other things are concerned. Therefore, it has to be covered by the pension rules. Now, to save time, I will not refer to all the judgments, but my learned friend has referred to some of the judgments decided by this Honorable Court. In none of the cases, this Honorable Court said that even if there is break and interruption in service, it shall be treated as a pensionable service. Rather, this Honorable Court in all the cases has categorically stated that to attract the definition of public employment, to treat the service as a pensionable service, there should be continuity in service and there should be no interruption in service. Very clear. And at the course of repetition, none of the judgments has said that even if there is break or gap or interruption, it shall be counted for the purpose of pension. None of the judgment has said that. Therefore, the service has to be continuous, the service has to be without any gap or break, and the service has to be without any interruption throughout the service. Am I clear, Lordship?
Yes, yes.
Now, we have to ascertain the service of the respondent number 3. His initial appointment as on contract and subsequent appointment on regular basis through recommendation by the NPC. And before I rely on my documents, first I would like to refer to paragraph 2 of my affidavit, Lordship. Paragraph 2, page 2 of affidavit in opposition of respondent number 3.
Yes.
May I read, Lordship? That before answering to the arguments made in the writ petition, this tribunal picks to question the maintainability of the writ petition to the effect that there is no violation of any fundamental rights or legal rights of the petitioner. Moreover, there is no cause of action, and as such, the instant writ petition is premature, and therefore, the instant writ petition is not maintainable either on facts or in law. The instant writ petition is nothing but an afterthought in view of the notification dated 8/12/2022, by which Engineer Kahuli Sema was allowed to go on voluntary retirement with effect from 21/1/2023, whereby the post of Engineer-in-Chief falls vacant with effect from 21/1/2023. Further, considering the issues raised in the writ petition, which involves the issue of retirement and pension in respect of respondent number 3, the Accountant General ought to have been implicated as a party respondent. However, for the reasons best known to the petitioner, the Accountant General have not been met as a party respondent, without whom proper adjudication pertaining to the retirement and pension may not be possible to arrive to a logical conclusion, and as such, the instant writ petition is not maintainable for non-joinder of necessary parties. The tribunal further picks to make the necessary submission at the time of hearing. Now, two aspects here, Lordship. Firstly, in order to invoke the writ jurisdiction of this Honorable Court under Article 226 of the Constitution of India, it is the bounden duty of the writ petitioner to satisfy this Honorable Court that he has a legal right to invoke the jurisdiction of this Honorable Court under Article 226 of the Constitution of India. My question is, what legal right or what fundamental rights of the petitioner has been violated? My learned friend has argued for about more than 3 hours. I have not been able to get any point that his legal right of this has been violated or his fundamental rights have been violated. The writ petition has been just filed because of the fact that one engineer, Gauhati, who was the number 1, she was made to be voluntarily retired by a notification of 8 December 2022 with effect from 21st January 2023. In view of that, he must have thought, the writ petitioner must have thought that, oh, if I do something, then I will get the opportunity to reach the post of Engineer-in-Chief. And that will be possible only when the respondent number 3 do not disturb him. That must be the possible and apparent reason how the writ petitioner filed this writ petition. Therefore, Lordship, my submission is there is no violation of any legal right there is no violation of any fundamental rights. Therefore, the present writ petition is not maintainable at all. Therefore, it deserves to be dismissed at its threshold. Second aspect, with regard to the retirement and pension, Lordship is well aware, who is the competent and appropriate authority to give a direction or to do this job. If a person retires, especially the gazetted, because Accountant General, they maintain the gazetted officers only, the service books. Therefore, my pay slip, my first pay will get only when the Accountant General issues a pay slip. How Accountant General issues the pay slip? On what basis? Basing on what? There has to be some document. They will not just so much to issue some pay slips. Pay slips will be issued on the basis of the appointment of an officer. Any officer, including the writ petitioner as well as the present respondent number 3. When the Accountant General has issued the pay slip, they have issued on 18th of April 1989. Therefore, unless an officer is issued a pay slip, I believe no salary will be released. The very basis of issuing the salary of a government servant, of a gazetted officer, is the pay slip. After getting the pay slip, only the salary will be released. Therefore, if any issue pertaining to the retirement and with regard to the pay, joining, is Accountant General will not be relevant to consult. And in fact, it's to my information, before issue of the order, the pioneer as well as the law department, apparently they have sought clarification from the Accountant General about the date of issue of pay slip and the date of retirement. Thereafter, only the correction has been made by the government. Therefore, it will be the Accountant General who will be in a better position to say when the writ petitioner is retiring, when the respondent number 3, that is the issue in this present case, join, and when he is due for retirement. But for the reason best known to the petitioner, the Accountant General, who is a necessary party, has not been implemented as a party respondent.
So, okay. But in between the cases also, certain rectifications can be made. You can pray for impleadment at any time. All through this matter, that has not been raised, is it?
That is why,
How many
Lordship,
times this matter has been
I have
listed?
met. It has come up for admission hearing only.
Okay.
Whether the writ petition should be admitted or not admitted, actually that should be decided. But
That's
then
what.
we have straight away,
Gone for
considering
the
the
hearing,
urgency
full
involved,
hearing.
considering the urgency involved, this matter has been taken up for hearing at the admission stage. Now, if at all the petitioner wants to implead the Accountant General, it is up to them. But I would not advise. Rather, I would submit that the writ petition is liable to be dismissed for non-joinder of necessary parties because Accountant General ought to have been a necessary party in the case. Now, may I kindly again draw your Lordship's attention to the affidavit in opposition, page number 20. My initial appointment on contract. How I was appointed, on what condition, on what terms and conditions, all these are mentioned in this contract agreement. It is a type copy. Xerox copy is not very clear, so may I rely on the type copy. This was signed between the petitioner and the government of Nagaland. This was made on 15th October 1987. 1987. My initial appointment was for a period of 6 months with a condition to extend. And my service have been extended from time to time. Now, my learned friend has referred to the contract agreement with regard to the notice. So, Lordship may kindly see the terms for termination of the contract in page 21, paragraph 4. Either it can be by the government or by the petitioner from either side by giving 1 month notice without assigning any reason. I will refer only to that. This was executed on 15/10/1987. Lordship may kindly again come back to page 20. If any of the parties do not comply or violate this agreement, what is the consequences? Kindly come to paragraph 2. Above that, just 3 lines above paragraph 2. The sentence starts from consequent. Has your Lordship got it? In page 20, paragraph 2. Just above that, 3 lines from above paragraph 2.
3 lines above paragraph 2 means the last portion of paragraph 1, isn't it?
Consequent on violation. Has your Lordship got it? Consequent on violation of terms.
Yes. The last portion of para 1.
Yes, correct. Consequent on violation of terms of contract agreement by him, that is by the petitioner. Respondent number 3. Action will be taken to that extent of forfeiture of his security deposit of rupees 500. So I have been asked to deposit security of rupees 500, which is a part of the agreement. Lordship will find in the agreement. And if I do not comply or violate the terms given in the agreement, that is by giving 1 month notice, I'm required to give. But suppose if I don't give 1 month notice, like the present I have done, immediately I have resigned after getting the nomination from the recommendation from the NPC. On 8th of March 1989, I have submitted resignation. So that is non-compliance of the terms of this agreement. What will be the consequences? At best, the security deposit which I have made, that will be forfeited for non-complying to the contract agreement. I have not got that. Therefore, by relying on this agreement, the petitioner is not going to benefit anything, Lordship. Now, kindly come to my resignation, that is page 25. And before the resignation, I would like to refer to the intimation letter by the NPC, that is at page 34. I'm sorry, the copies are not very clear in the page 34, but it is legible. This is the recommendation by the Nagaland Public Service Commission, 8 March 1989. Has your Lordship got it? Let me just not read out this, but then there is one condition here in this letter. Suitable, just read, second paragraph. I am, however, to make it clear that the offer of appointment will be made to you only after the government finds.
There's no typed copy. Is
Sir,
it?
Now, let me read the better copy. Have satisfied themselves after such inquiry as may be considered necessary, that you are suitably in all respect for appointment to the service, and that you are in good health and bodily healthy and free from any physical defect likely to interfere with the discharge of your duties. The offer of appointment will also be subject to such other conditions as are applicable to all such appointees under the government of Nagaland. The receipt of this letter may be acknowledged. Why I'm referring to this is just a recommendation with certain conditions, and I must fulfill all these conditions. Then only I can be considered for appointment. That is what it says. That is, this is by the Secretary, NPC, and above, Lordship will find that this has been addressed to me in the care of Sebastian, Nagaland Civil Secretariat. Now, if, even after issuing this, if the respondent number 3 is not found suitable, he will not be appointed. Now my question is, the writ petitioners are claiming that, look, he was appointed with effect from 8/3/1989, and he worked as a junior engineer up to 8/3/89. Therefore, there is no break at all. This date is already admitted. Then, accepting that contention, I would like to pose a question. Just because, on the basis of the recommendation, just because the NPC has recommended, how this part of this period can convert to a pensionable service before appointment. Appointment is admittedly on 17/4/1989. Then before my appointment, whether this part of the service, that is 37 days, can be treated as a pensionable service. If so, again, if it is treated as a pensionable service, 37 days after resignation, because resignation is on 8, I will come to that, 8 March. So after my resignation on 8 March 1989, I have not, resignation was on 9th, sorry. I have not attended the office, either as a JE or as an assistant engineer, STO. After resignation, going by the contention of the petitioner, they are saying that I was in service. If so, I'm putting a question, Lordship. If so, whether during this period of 37 days, from the date of resignation up to the date of appointment on 17th of April 1989, I was working as a junior engineer or I was working as an assistant engineer. To treat that period as in service, on 9th of March 1989, I have resigned as a junior engineer. I am yet to be appointed prior to 17/4/1989. Before my appointment, whether my service can be treated as an assistant engineer by treating this service as a pensionable service. Very important. The service has to be pensionable as per Section 2 of the Act. And to be pensionable, there should be no interruption, there should be no break, there should be no gap in service. And going by Rule 13 and 14 of the pension rules, CC's pension rules, when there is interruption, I am not eligible and entitled to pension.
Yes, I think it's time
I
for
think,
break.
yes.
We'll continue at 2.
Lordship.
Let's see, come along.
I will try to complete before 3. So that my
Please
learned
do,
friend
please
will
do.
also reply.
Another one now. Yes. Yes.
May I continue, Lordship?
Hmm.
I was referring to my affidavit in opposition, more particularly page 25.
Yes.
That is the resignation letter submitted by the respondent number 3 after he got the recommendation letter.
Hmm.
May I read, Lordship?
Yes.
To the Chief
Wait,
Engineer,
affidavit
PWD,
in opposition is,
page 25. Affidavit in opposition of respondent number 3,
yes, yes.
page 25.
Hmm.
Let me just read the body of the letter. Sir, with due respect and humble submission, I would like to inform your kind office that I am selected by the NPC for the post of Engineer Civil PWD, letter dated 18 March 1989. I therefore resign from my post as GE under the establishment of SE1 PWD Kohima to enable me to join my new post. This was submitted on 9 March 1989 and which was received on 9/3/1989. So after the resignation, I was not in the service also. And before my appointment, as I was mentioning, I was not in active service. If going by the petitioner, if I was in service, then as after resignation as GE, in which post I was holding as a GE or assistant engineer before appointment. So the thing speaks by itself that it makes no sense to say that I was in service after 8 March till my appointment on 17 April 1989. And next page is the offer of appointment. This is 13 March 1989. Of course, it was signed on 15/3/89. So in order to avoid any confusion,
Yes, yes.
although it is shown on the top, it is 13 March 89, but down below, it is signed on 15/3/89. So this is the offer of appointment. May I read, Lordship? The undersigned is directed to inform Shri Yambi Molota that the Nagaland Public Service Commission has recommended for his regular appointment as assistant engineer under Nagaland PWD. Therefore, Shri Yambi Molota is directed to intimate this department his acceptance of the offer of appointment in the post. It is offer of appointment. He is also hereby directed to fill in the attestation form, a copy of which is enclosed herewith, and resubmit the same duly filled in, together with the medical fitness certificate issued by the competent medical authority to this department immediately for further action. So this is the offer of appointment. Respondent number 3 may be appointed or may not be appointed. This was on 15 March 1989. It's only an offer of appointment. And on this day, when it was intimated in the address of 1 Sebastian, the respondent number 3 was not working because his resignation is 9 March 1989. Next page is the letter of appointment notification. Type copy, Lordship will find at page 28. This is notification dated 17 April 1989. I may be allowed to read this because effective date is given from a retrospective date here. Having been selected by the Nagaland Public Service Commission, the Governor of Nagaland is pleased to appoint the following persons shown in the order of merit to the post of Assistant Engineer Civil Class 1 Gazetted under Nagaland PWD temporarily in the pay scale of so-and-so plus inner line compensatory allowance of 25% of basic pay and all other allowances as admissible in the Nagaland from time to time with effect from, this is important, 8/3/1989 and are posted against the post indicated below. And serial number 1 is the one who has been resigned on 8 December 2022 with effect from 21st January 2023, serial number 1. And serial number 2 is the respondent number 3. And serial number 4 is the petitioner. Both of them were recommended on the basis of the same selection, and they were appointed on 17 April 1989 with effect from 8/3/89. Government affidavit said that, look, they were appointed in 489, but for the purpose of granting seniority benefit, since the NPC has already recommended on 8/3/89, it was given effective from 8/3/89. This is merely for granting seniority benefit. But in terms of the provisions of the Act, the pensionable service of the petitioner will be counted only from the date of appointment, that is 17/4/1989.
Okay, next is for date of joining. No, there's no date of joining.
Same date, assumption of charge, next page, page 29, on 17
transfer
April.
of charge, yes.
Yes, in the afternoon. So pensionable service should be counted from the date of assumption of charge, that is 17 April 1989. And since, as per the definition of public employment, the service should be pensionable service, appointment to the post should be to the pensionable service, and it should count for pension. AHE will be the competent authority to say that from which date the respondent number 3, for that matter, including the petitioner, should count for the purpose of pension, as per the definition in the Act. Because public employment should be a pensionable service and it should count for pension. Therefore, my pension will start recording from 17 April 1989. Next page is page 30, Annexure F. This is the pay slip which was issued on the next day of joining, that is 18/4/1989. Showing the date. And then page 31. This is the pay salary slip, Lordship. And then in the box, in the column, second column, 18/4/89 will be shown from so-and-so. And then total of amount is shown in the bottom, 2706.50. On the extreme right column, column 3 and 4. In the box, fresh appointment as STO, TC, PWD on probation period of 2 years, with effect from 18/4/89 up to 18/4/1991. And then page 32 is the first pay fixation up to the ROP, but type copy, Lordship will find it page 33.
Okay.
This was fixation of initial pay. First fixation of pay, because their appointment is 89, ROP came in 1993, and then pay was fixed by this order, serial number 7. Basic pay in existing scale of so-and-so, 1045. Date of next increment, 1/4/1991. So this was the basic pay. As per the 1984 ROP, the pay scale of STO is 1010 and 35. It comes to 1150. Therefore, in 1990, the basic pay was fixed at 1045, which is shown in the box, Lordship, in the order, which implies that the date of entry in the service of the respondent number 3 is 1989.
Okay, now before we go any further, Now, this point is harped over and over again that the AG should have been made a party. Okay. Now, the petitioners, since this is at the admission stage, the petitioners, are you in any way disputing with the payslip and the submission made that the pension also is calculated by the AG and the AG should be a necessary party? Now, do you feel for your case you need to make the AG a necessary party, or you're okay with the submissions or the documents filed which has been issued by the AG?
No, AG is not a necessary party.
Okay, fine. Then
Because
we will go ahead then. I'm
Yes.
just giving you a chance. Yes, yes. Yes.
Let me switch over to page 34. This is the, and on the earlier occasion, I have just referred to Lordship, so
Yes,
I need
yes,
not read
yes,
this.
yes.
This is the offering letter.
Hmm.
And then the next page is page 35. The act, I have already referred to
Yes.
the relevant provisions, so I need not waste time on this. 37 is also the 2000 amendment made in 2009.
Hmm.
So I have made some submissions there.
Hmm.
And then page 39. Handwritten copy is not very clear. At page 38, so I'm referring to the type copy, page 39. This is an application submitted by the respondent number 3, framed for regularization of STO post from April 1989, and request was made on 9/9/1999. This was submitted before the Retirement Act came into force, contending that from April 1989, our preparation period may be regularized, because after the preparation period is over, government has to issue an effective order regularizing our probationary period. So that was, this document has been enclosed so as to show that, look, we have already completed the probationary period, so kindly regularize us. There also, the contention was taken April 1989. Nowhere it is mentioned about 87, even 88 also. Not from the contract service. I have never claimed any benefit also. Nor the government has given any benefit of past service. And earlier cases which were decided by this honorable court, in all the cases, benefit of the past service were given one way or the other, by way of leave account carry forward, same service book was maintained, salary was made, all this. But here, absolutely, there is nothing of that sort in this particular case. Now, let us come to the appointment, the regularization order. Page 41 is the type copy. This was on 7 October 1994. Let me read the third paragraph. Now, therefore, the Governor of Nagaland is pleased to regularize the probation period against the post of STOPWD from the date above against each on completion of probation period. And then serial number 3 is the respondent number 3, and serial number 4 is the writ petitioner. So date of joining in the middle column, Lordship will find 8389, 8389. So from this date only, everything was counted. And then the date of regularization is on the extreme right column, 8391, 8391. In respect of respondent number 3 as well as the petitioner, same date is also mentioned.
Yes.
Now, page 43. This is to show the leave account. Because for a government servant, leave account starts counting from the date when an officer joins the post. Now, this is the leave account issued by the Accountant General. Second column in the box on the top, OKA, Yambi Molota, STO PWD, 120 EL days, earned leave days. So just below that, Kohima, 17/9/1996, certified that earned leave for 120 days and HPL for 140 days is admissible from 18/4/89. This is the date of issuing the pay slip, Lordship, by the AG, to 18/4/96 for engagement of so-and-so days earned leave due to so-and-so, so-and-so. Now, in the bottom of the page, the officer has not availed to any leave as per our office record with effect from 18/4/89 to 18/4/96. Here also, to show that it is from 18/4/89.
Okay, yes.
So leave account commences from 18/4/89, and leave account of junior engineer has not been carried forward, unlike other cases. Now, my learned friend, the counsel for the state, has also been referred to the state civil list. Now, I would also like to refer to page 44. Relevant portion is at page 46. Here, serial number, Nagaland Public Works Department. Now, on the top box, Lordship will find 1, 2, 3, 4, 5, 6. On the sixth column, on the top, date of first entry into government service. That is column number 6. Contract service not treated as government service. So, serial number 10 and 11 are the respondent number 3 and the petitioners. And Lordship will find 8/3/89 is shown in respect of both of them. That is the date of appointment.
Yes.
Past contract service in the post of junior engineer has never been taken into consideration, has never been taken into account, even in the civil list also. So the authentic record maintained by the government shows that the date of entry is 8/3/89 only. Now, page 47, annexure N. This is entry in the PIMS. As the other day, Lordship was also inquiring, since when the PIMS have been introduced in the state, it is all over the country. In the state, sometime in 2016, this was introduced in the state. And in the middle of the page, Lordship will find the for the category, religion, marital status. I'm referring to the extreme left, spouse name, mode of recruitment in the middle of the page. That is by NPSC. And then next is superannuation. 31/3/2024. Just above that, DOJ, date of joining, that is 8/3/89. And then down below, in the bottom, effective date on the extreme left column, effective date, that is 3/2/21, promotion to chief engineer. So now, the most interesting part, that will be page 48, annexure O. The manner how this order has been issued. By this order, under section 3 clause 1 and section 3 clause 2, the petitioner, the respondent number 3, along with 4 others, were made to be retired by a common order. And the respondent number 3 is shown under column 1. Engineer Yambe Moluta, Chief Engineer, PEP, Police Engineering Project, Kohima. Date of birth, 18/5/1964. Date of entry into government service, 15/10/87. This is the contract period, date of joining in the junior engineer. Length of service, superannuation, 31/10/2022, length of service. So I was made to retire, taking the past service of junior engineer, and by computing all this period, I was made to retire on 31/10/2022.
Yes.
And down below, just second last serial 14, copy 2. all concerned officers. It is shown all concerned officers. This order of retirement has never been intimated to the petitioner, respondent number 3. But Lordship will find in the same order, column serial number 3, Shri L. Paukam Phum, STO under Executive Engineer PAP Alichan.
Where's that? Copy 2, isn't it?
Yes.
Copy 2, yes.
All
Number 1
serial
is?
number 14.
14.
All concerned officers.
Yes, yes. all
And then I'm referring to again middle column, the chart, who are the persons who are retiring. Serial number 3, Shri L. Paukam Phum, STO under EPAP Alichan. And then his date of retirement is 31/8/2022, end of service. This officer and the petitioner are in the same office. Respondent number 3. Respondent number 3 is the controlling officer. While processing the case of serial number 3, one STO, L. Phum Phum. This is the time when the respondent number 3 came to know that he will be retiring on this date. Kindly come to paragraph 15 and 16 of the petition, Lordship. Paragraph 15 and 16. In what manner? Yes, and in what manner and how they have issued the retirement order. Petitioner have complained about the hand and glove of being extraordinarily fast in issuing the revocation order, how they have done, how they have issued the release order, retirement order in an unusual manner and unusual delay for not communicating to the person concerned who is retiring on the basis of a wrong calculation of the dates and the date of joining. Paragraph 15 and 16. I may be allowed
page
to
11.
read.
Is it page 11?
Yes, correct, Lordship. Lordship is faster than the council.
Okay.
That's how we find it more comfortable. May I read, Lordship?
Yes.
Paragraph 15. That the statements made in paragraph 16 of the writ petitions, this tribunal picked to state that the command order dated 19/7/2022, this is Annexure O, page 48, allowing the respondent number 3 and others to retire from service was never furnished, endorsed to the respondent number 3, although it was portrayed in the notification that copies were sent to all concerned officers. In this regard, the tribunal begged to state that one Shri L. Paukam Phum, who was serving as STO under Executive Engineer PEP Alichan, who was due to retire with effect from 31/8/2022 on completion of 35 years of length of service, shown under serial number 3 of the government order dated 19/7/2022, was processed before the respondent number 3 in connection with his retirement. It is from this case the petitioner discovered the order dated 19/7/2022, showing his date of retirement as 31/10/2022 by length of service. Since the respondent number 3 was appointed on 17/4/1989 with effect from 8/3/1989, the respondent number 3 immediately submitted the representation on 28/9/2022 to the government for making necessary correction. On consideration of the representation, which was verified with the authentic records, the imbued notification dated 22/12/2022 was issued by the respondent authorities, revoking the retirement order in respect of respondent number 3. 16. That the statements made in paragraph 17 and 18 of the writ petition, this tribunal picked to state that the noting of different officials in the file are mere expression of their personal opinions, and such opinions are subject to be deferred, corrected, basing on the authentic official records. The relevant consideration for taking any decision must be based on authentic official documents and orders, and therefore, petitioner will not get any benefit or advantage by mere expression of opinions by different officers in the file. The statements made in paragraph 18 vividly demonstrates the hand of the petitioner in all the file movements in the PNAR department. This is evident from the fact that the respondent number 3 has never been officially intimated about his due date of retirement with effect from 31/10/2022. There is some mistake there, typing mistake. In terms of the government notification dated 19/7/2022, and everything has been done in a surreptitious manner, so as the case of the respondent number 3 is concerned. So this is how the order has been issued and processed. I have stated how I have received, and immediately after getting this, after discovering this, the respondent number 3 submitted the representation, which is at page 49, addressed to the Secretary, Works and Housing, Government of Nagaland, subject corrigendum to my release order regarding page 49. It was on 28/9/2022. Sir, may I have the honor to draw your attention to the following for your necessary action and decision, please. Number 1. In my release order number so-and-so dated 19/7/22, the date of birth is correct. However, the date of entry into government service is erroneous and should read as 17/4/1989 with date of superannuation as 31/4/2024 and not as rendered annexure 3 and 4. 2. It is to be stated that I have been working as a junior engineer in the department on the contract with appointment order number so-and-so dated 14/10/97 and 1987, but had submitted my resignation on 9/4/1989. With reference to Clause 2 of PNAR Office Memorandum dated 29 March 2017, the question of continuous service in my case does not arise as it is not the same post nor continuity of service exists. Therefore, it is requested that the matter be cross-verified and my release order, along with PIMS entry, be amended to enable me to serve the government to my fullest capacity. That was the representation submitted by the petitioner, and basing on consideration of the representation, the present ambient order dated 22/12/2022 has been issued. That is at page 51. Although that order of 19 September 2022 was issued, there was no release order. The matter was examined in the PNAR Law Department, referred to all the nodal agencies, and revocation order has been issued basing on the authentic record. And the retirement order of 19 September 2022 has never been served to the petitioners. And so far as this Indian order is concerned, Lordship, government in their affidavit have stated that they have corrected the mistake. While responding to the contention of the government, the counsel for the petitioner has made the submission that where is the mistake? There is no mistake at all. There is no question of correction of mistake. The correction of mistake, as stated in the government affidavit, to my understanding and to me, is the correction of the retirement order, which was erroneously issued. That has been corrected by issuing a notification. So, the correction stated in the government affidavit is correction of a wrong action committed by the state respondent. And one cannot say that you can never commit a mistake. Even the probable word says the error is human. It's being done by human. And there are so many vested interests are also involved. Therefore, the reason why I'm saying this is, at least if I'm to go on retirement, at least I'm the right person to know when I'm retiring, and I should get a copy of that. What prevented the government to serve a copy to me, to retire me from service. I have not received till date.
Okay, just one thing, page 49.
Lordship.
Just come to your page 49.
Yes,
Now, the third point,
yes,
which says with reference to PNAROM so-and-so dated 29 March 2017.
yes.
What is this?
This is the office memorandum, which is already a part of the writ petition, Lordship.
The question of continuous service in my case does not arise.
Yes, this is pertaining to, it's in the writ petition. This is under office memorandum, 31st, just a minute. Page
March
49.
2017. I'm just.
Page 57 of the writ petition. No, this is.
No,
31st
this
of-
is August.
Yes.
Because he refers to this, isn't it? 29th March 2017. The question of continuous service in my case does not arise. So there must be a letter saying he has a continuous service.
Yeah, that is not on record, but Lordship, that notification is, I think that is already.
Okay, it's not on record.
Your Lordship, this OM has already been superseded.
Okay, it has been
Yes, it
superseded.
has been superseded.
Oh, okay.
By this latest one,
Ah.
page 57, 31st August 2017, by this has been superseded.
Okay, superseded by 31st August.
Yes,
Oh, but then he referred to the wrong one because this representation was
Yes,
made in
yes,
2022.
yes.
So he's referred to a superseded one. 2017,
yes.
August.
That talks about the resignation also.
So he's referred to something which is no longer
Yes.
applicable. Okay.
Now, in my representation, just next page is with regard to 31st August 2017. Here, paragraph 6 has been referred by both the councils. Now, by reading paragraph 26, paragraph 6,
You're in page?
page 53. Paragraph 6. My learned friend, R. Irello, has referred to this paragraph 6 and tried to emphasize under Rule 26. Rule 26, going by Rule 26 of the pension rules. Resignation forfeits past services. Clause 1. Going by clause 2, even if resignation is submitted, if proper permission is taken to apply for a particular post, then in such a situation, under certain conditions, even if a person is resigned, his past service will be, even if there is a break, some benefit will be given, taking the break as technical cap. How that is possible? Suppose a person in Delhi, while working in a post, he applied for a post in Gauhati and he got selected in the new post. In order to join in the new post at Gauhati, those days pension rule is of 1972, he has to resign from the post, earlier post, then only he can be allowed to join in the new post, new selected post. In such a situation, definitely the person will travel by train, or even if by flight also, 1 or 2 days gap will be there. But in order to grant benefit to the employee who is joining the new department, they will be given benefit of past service by treating that break as technical break, technical gap, as if there is no break. Even if he resigns, he will get a past benefit. This is possible in a situation where, because here people are up to the government service. In the other parts of the country, where in the advanced states, people are not up to the government service. Rather, they want to leave the government service at the earliest. Therefore, they apply voluntary retirement. But to allow for voluntary retirement also, a particular length of service is required. Otherwise, he will not get the pensionary benefit, voluntary retirement benefit. Therefore, unless that earlier service is connected with the new appointment, they are not qualified. In maximum cases, in most of the cases, such a situation will be available. That is the reason why this clause has been inserted, and many officers are appealing in that. Now, coming to the resignation again. Under Rule 28 of the pension rules, CC's pension rules, there can be this can be condoned. There is a provision for condonation. Condonation of interruption in service. Rule 28. In absence of a specific indication to the contrary in the service book, an interruption between two spells of civil service rendered by a government servant under the government, including civil service, rendered and paid out of the defense services, estimates or railway estimates shall be treated as automatically condoned and the pre-interruption service treated as qualifying service. Clause B. Nothing in Clause A shall apply to interruption caused by resignation, dismissal, or removal from service or for participation in a strike. 4 conditions. Number 1 is resignation. Others we are not concerned. If a person resigns, break cannot be condoned. Rules are very clear. It cannot be condoned when there is an interruption. Therefore, Lordship, even going by the office memorandum also, in no way the contract period can be brought in and connected with the fresh appointment. Now, coming to the last annexure, page 54, annexure S. Here, the type copy starts from page 62. Of course, this document has also been referred to by the Learned Counsel for the State, and I would also like to refer again to page 64. Here, Roman 6, in the column in the first line, respondent number 3 is shown. Respondent number 3 in that case was serial number 9 in the chart, in the column. Engineer K. Teno, appointment, regularization. There was a seniority dispute. In order to counter this case, government has filed the counter affidavit in that case. And here, in the bottom of the box, Lordship will find serial number 21 and 22. Their date of joining, appointment, is shown as 8389. Government has taken the date of joining in the service as 8389 in affidavit. And if we count from this 8389, it will go to 31/3/2024. So petitioner, respondent number 3 has enclosed this affidavit filed by the government in his representation also. So appointment as junior engineer on contract basis was never effectual, and no service benefit whatsoever of the junior engineer has been carried forward. Therefore, it was counted from the date which was made effective from 8/3/89, although appointed only on 17/4/1989. But effective date was made from 8/3/89. Therefore, counting from this 8/3/89 as contended by the government, as contended by the petitioner, 35 years will be completed on 31/3/2024. But taking the contract service of junior engineer, by including the interruption, they have made to retire the petitioner by a mistaken order, which was rectified by the government, taking it as a mistake, which is not based on record. So this was rectified. So what is wrong there? A mistake can always be corrected by the government.
So now if it is 87,
Lordship.
the respondent number 3 is supposed to retire by
30th October,
last year.
yes,
So what is
2022.
happening now? It's been kept in abeyance?
He is working as, even in the
Okay.
department.
So-
He is not released yet.
He's not released yet. Has this court passed an order keeping the matter in abeyance, interim order, whatever?
Status quo shall
Status
be
quo
maintained.
has
as
been
a-
maintained.
Yes.
Okay.
So on that day, the petitioner was working.
Okay, since he was working status quo, so he's
Yes,
still working.
Lordship. Now, only on 4 points I would like to reply. Of course, it will be only 3, because during my submission, some
Okay,
points
they have
have already been
addressed.
replied.
Yes.
I don't feel it appropriate to repeat. A submission was made that the advice tendered by the law department and the advice tendered by the PNR department is wrong advice. That is the submission made by the counsel for the petitioner. Why it is wrong? Where is wrong? What is wrong? They could not specify how it is wrong. Rather, it was perfectly done basing on the authentic records. And correction was done by revoking the order, by the order dated 22/12/2022 on the basis of the authentic record. Second submission was that on the question of resignation, the council has submitted that resignation has never been received, accepted. Now, if assuming that my resignation is not accepted, and since it is not accepted, he is deemed to have been in service, then my question is, after the resignation, and since it is not accepted, you are deemed to be in service. That is what they are trying to project. Then, in which service I was working, how much salary I have drawn, in what manner, all this will come. You mean to say that I'm still holding the post of junior engineer since my resignation has not been accepted by the authority? Ultimately, that will be the logical conclusion. That no, you are still the junior engineer since your resignation has not been accepted. Even now, government is unable to show the record when it was accepted, how it was accepted. But petitioner is contending that resignation has never been accepted. That means I'm still a junior engineer now, if we are to go by the contention of the petitioner.
Yes, go ahead.
Now, the third point was on the point of rules of executive business. My learned friend has referred to Rule 8, Rule 10, but all these are irrelevant to me because it has nothing to do with the financial implication of the state. No new post is created, no post is abolished. Person may go, person may come, post is there. So there is no financial implication. Therefore, it is not necessary to go through all these procedures. So the rules of executive business, since there is no financial implications, it is irrelevant so far as this present case is concerned. Now, the last one. The council has submitted that where is the question of correcting the mistake? No mistake has been corrected. That is what the submission has been advanced. The correction of mistake, as I have mentioned slightly, this correction of mistake in common affidavit means to say that the retirement order was incorrect, it was a mistake because it was not based on record, because it was contrary to the records. Therefore, on verification of all the authentic records, on verification by the PNR, Law Department, and the Accountant General, this revocation order 22/12/2022 has been issued. Therefore, the correction of mistake mentioned in the common affidavit is about the revocation of the order of 19 September 2022 order, which was illegally issued without basing on any authentic records. Now, I would like to refer to Rule 13 and 14 of the CCS pension rules. As I was submitting earlier, the basic fundamental principle of pension rules is that there should be continuity in service, there should be no interruption in service. So I would like to refer to Rule 13, commencement of qualifying service. Has your lordship got it? Subject to the provisions of these rules, qualifying service of a government servant shall commence from the date he takes charge of the post to which he is first appointed, either substantively or in an officiating or temporary capacity, provided that officiating or temporary service is followed without interruption by substantive appointment, without interruption by substantive appointment. Appointment should be substantive and there should be no interruption. In my case, the substantive appointment was on 17th of April, 1989. Earlier appointment as a junior engineer was a fortuitous appointment. It was a contract appointment, which cannot be treated as a pensionable service.
Okay.
I will cite some rulings also. Now, I would like to come to some citations. The first case, which was referred by my learned friend, the first case I would like to refer. This is a case decided by the full bench, and this case is pending in the FX court.
Okay.
Normally, FX court do not admit any petition, especially on a service matter, unless there is some substantive point to be considered. Otherwise, in few seconds, it will be dismissed if there is no reason to be admitted. I have given the list of books, serial number 1, that is
Yes.
2021 2 GLT 710, paragraph 21 and 22. This is to show that continuity in service should be there. Flag 1. Oh, no. In this case, Lordship, what happened?
Yes.
Petitioner was initially appointed an ad hoc in the Rural Development Department as Assistant Project Officer, and she was working on ad hoc, and then she appeared in a selection board, and then she was selected, and she was appointed with effect from 1st June 1986.
Oh,
Earlier, she was appointed in 1984. on ad
Asangla
hoc.
Iyer.
Yes, Asangla Iyer.
Yes.
Now, there was a seniority claim and dispute on the seniority issue. So Asangla Iyer filed a writ petition. I was one of the counsels there. Of course, I was assisting my senior. She claimed seniority with effect from 1984, from the date of ad hoc appointment. My initial appointment is this, so my seniority should be counted from 1984. But then this honorable court has denied that no, your seniority will be counted from the date of regular appointment, that is 1st June 1989. So the petition was dismissed.
Okay.
She has accepted that. So all along it came. Thereafter, she, before retirement, she filed a case saying that, look, when I have claimed my seniority from ad hoc appointment, you have not given, and you are denying me seniority. So since the seniority was made to be counted with effect from 84, my length of service should be counted from, that was
89,
denied.
89.
86 only, I was regularly appointed. So from 86, I should be counted, in which case I cannot be retired now.
Okay.
That was allowed. And then writ appeal went, and then writ appeal in the appellate court has referred to a full bench. Full bench has examined and then found that, yes, although she resigned, there is no record to show how and when she has resigned, number one. Number two, although, even assuming that resigned, she worked up to 30th May, 31st May 1986, and on regular basis appointed on the 1st, on the same post, APU only. Therefore, entire length should be counted. There is no break, there is no interruption, there is continuity in service, so entire length should be counted. And this honorable court, the full bench, while deciding the case, categorically observed that under the definition of public employment, because reference to the full bench was to clarify what is the definition of public employment. And the full bench has clarified that appointment to any pensionable public service or post. Therefore, it should be pensionable. It should count for pension. That has been reiterated by the full bench. So the service must be pensionable service. It should count for pension. However, Asangla Iyer has taken the matter to the apex court. It is pending. But that is with regard to, I'm only referring this case to show that.
This matter is still pending.
Yes, but I'm referring this to show that, look, all along, consistently, to treat the service as pensionable service, to attract the definition of public employment, the service should be continuous, there should be no interruption, there should be no break or gap in the service. That is how the ratio has been laid down. The second case, Lordship.
Waiter, in this case, ad hoc appointment, first appointment was as what?
Ad hoc appointment.
As what?
Assistant Project Officer.
Okay.
And the regular appointment was also in the same post.
Same, okay.
And Lordship, just this is little out of the context, but then relevant also. The state government has been issuing memorandums after memorandums, and a case will be decided. Basing on that, another office memorandum will be issued. So many office memorandums have been issued by the government, maybe because of the fact that they were not very clear about the concept, what is meant by pension, pensionable service. Now, initially, of course, this is little away from our present case, but then it will be relevant. Initially, the government has issued an office memorandum. That was many years back. Public employment will be counted, the length of service of 35 years will be counted only from the date of regular appointment. That was the office memorandum. Basing on that, few individuals have filed a writ petition saying that, look, our contract ad hoc appointment should not be counted. As per the office memorandum, our service should be counted from the date of regular appointment. And in fact, basing on that, some officers have been retired, counting their length of service from the date of regular appointment. Subsequently, few officers have filed a case contending that our service should be counted only from the date of regular appointment. This honorable court said, no, your appointment to the post on ad hoc was in the same post, and your regularization in the post was in the same post. Therefore, and there is no break.
Appointment.
It will be counted, entire length will be counted. That is okay. Taking the principle of the pension rules. There is continuity, no interruption, nothing. And in the same post. Consequent to that, government has issued an office memorandum again, showing that irrespective of the nature of appointment, if there is continuity in service, then irrespective of the nature of appointment, everything will be counted for computing 35 years of service, provided it is continuous. And in the same post. Subsequently, few cases came, their government has argued against their own office memorandum so as to defeat that particular case, and basing on that, another office memorandum was issued to the effect that only the entire service will be counted, even if the post will be different. So long as there is continuity in service. Substitute was included there. Again. Thereafter, in the month of May 2017, another notification was issued that when there is resignation, it will not be counted again. And the present OM is a continuation of that. But without clearly understanding apparently the pension rules. In some cases, government has released some officers basing on the carry forward of leave account, even after resignation. But Rule 9 of the CCS leave rule clearly says when an officer person resigns from the post, he forfeits all the past benefit of leave. But then, even if the officer is admittedly resigned, the government has agreed and accepted that he has resigned. Leave was carried forward.
Okay.
Contrary to the leave rules. Rule doesn't permit this. Therefore, apparently, in view of that, there are 3 cases pending in the apex court even now on the issue of retirement, of course, in different contexts, different factual contexts.
Okay. Not similar to this.
No,
Nothing
no,
similar to
no.
this. Okay.
Otherwise, I should not have relied also.
Right, right.
So, till date, the state government, it appears that they are not very clear what are the provisions of the pension rules. And that must be the possible reason why every now and then state government is compelled to issue one or the other office memorandum, one after another. Why? There is something wrong. That is why they are making some corrections. After one case, again, they are making corrections. Of course, there is nothing wrong in filtering the things. That is okay. So long as it is in accordance with the provisions of law, that should be welcome. We are not averse to
So
this.
we're dealing with the latest one, 2017.
2017.
Memorandum.
Yes.
For pension.
Yes.
So as it stands.
Here, page 53 is the relevant portion, paragraph 8. This will be taken care of by Rule 26, which talks about the resignation, and more particularly, Rule 1, resignation forfeits past services. And role 2 will be with regard to the technical resignation.
Okay, so the first cited case is pending in the
Because-
Supreme Court, so no need of discussing
Yes.
this, isn't it?
Now,
We'll come to the next
yes,
citation.
2020, 1 chiller.
Yes,
Here, paragraph 66 and 67. That is where, in order to treat the service as pensionable service, in terms of the definition of public employment, the service has to be continuous. There should be no break, no interruption, nothing.
okay.
So, and the third one is also on the same line. 2012,
Continuous.
5 JLR 675, paragraphs 177 and 178.
Okay.
This is the first case on the retirement issue. There is a series of cases here which is pending in the FX court now.
Okay, the first is 2 and this thing is concerning continuous service, isn't it?
Yes, yes.
Serial number 3 and 2 and 3.
Yes. All, 1, 2, and
Okay,
3
all of them,
are
huh?
all with regard
1,
to
2,
the
and 3
continuity
is continuous
up to
service.
4.
Yes.
And serial number 3 and serial number 4 pertaining to the same case, but the writ petition was in the serial number 3 and the serial number 4 is writ appeal. The name is different because there were series of cases. So the writ appeal was coined as Nisimich versus State of Nagaland. Serial number 3 and 4 are the same case, same page of
Case 1
cases.
and 3,
But-
yes, same person.
One is under a different caption in the writ petition and in the writ appeal, Nisimich. But all these are connected, all these are there, all these cases are there. Now, serial number 6 of the citations, next page. 2006 2 ACC 482, paragraph 21. Here, contractual employee, not government servants.
Okay.
So, this honorable court has decided so many cases treating a top substitute contract as pensionable and they can be treated as government servants. Treating as government servant, no problem. But whether the law allows it to be treated as a pensionable service or not, as a government service or not. So may I refer to paragraph 21, Lordship?
Yes.
You can see. It is on. Paragraph 20 and 21. Here, only paragraph 21 is given, but paragraph 20 will also be relevant. May I read, Lordship? There is no dispute that respondent number 1 was engaged or hired on contract to work as truck inspector for a period of 6 months from the date of joining or till the candidate selected by the UPSC joined on regular basis, whichever was earlier. The contract further stipulates that even if a regularly selected candidate did not join, respondent number 1 shall stand relief of the expiry of 6 months. In Director Institute of Management Development versus Pushpa Srivastava, it was held that where the appointment is purely on a talk basis and is contractual and by efflux of dime, the appointment comes to an end. The person holding such posts can have no right to continue in the post. It was further held that this is so, even if the person is continued from time to time on a talk basis for more than a year. In the state of Haryana versus Surendra Kumar, the respondent were appointed as clerks on contract basis. They filed a writ petition in the High Court for their regularization, which was allowed, and a direction was issued for payment of wages on the principles of equal pay for equal work and also regularization of their services. In appeal, this court reversed the judgment of the High Court, holding that as the respondent's recruitment was not met in accordance with the rules and you were appointed on contract basis on daily wages, they cannot have any right to the post as such until they are duly selected and appointed. This decision was followed by a three-judge bench in the state of Haryana versus Chiranjit Singh, and it was held that where a person is employed under a contract, it is the contract which will govern the terms of contract of service and not the rules framed under Article 309 of the Constitution governing the conditions of service to the post on which he is employed. It is therefore clear that respondent number 1 did not have any right to continue as trucks inspector after expiry of 6 months period for which he had been appointed. So when a person is appointed on contract basis, his service conditions are governed by the contract, not like that of the persons whose service conditions are governed by under Article 311 of the Constitution. I'm not referring to paragraph 21. It is strongly typed, Lordship. It is 20 instead of 21.
Yes.
Cell number 6.
Okay.
And serial number 7 and 8 are pertaining to definition of resignation. What is meant by resignation? So serial number 7, may I take to paragraph 22. Paragraph 22.
Yes.
May I read?
Hmm.
The principles in the context of the controversy before us are well enunciated in the judgment of this court in RBI versus Cecil Dennis Solomon. On a similar factual matrix, the employees had resigned sometime in 1988. The RBI pension regulations came in operation in 1990. The employees who had resigned earlier sought applicability of these pension regulations to themselves. The provisions once again had a similar clause of forfeiture of service on resignation or dismissal or termination. The relevant observations are as under. Then, in service jurisprudence, the expression superannuation, voluntary retirement, compulsory retirement, and resignation conveys different connotation. Voluntary retirement and resignation involves voluntary acts on the part of the employee to leave service. 2, both involve voluntary acts to operate differently. One of the basic distinctions is that in case of resignation, it can be tendered at any time, but in the case of voluntary retirement, it can only be sought for after rendering in the prescribed period of qualifying service. Other fundamental distinctions is that in case of former, that is resignation, formal retirement benefits are denied, but in case of latter, the same is not denied. In case of the former, that is on resignation, permission or notice is not mandated. This is very important. While in the case of latter, that is voluntary retirement, permission of the employer concerned is a requisite condition. 2, resignation is a bilateral concept and becomes effective on acceptance by the competent authority, yet the general rule can be displaced by express provisions to the contrary. In Punjab National Bank versus Peki Mittal, on interpretation of Regulation 20, Clause 2 of Punjab National Bank Regulation, it was held that resignation would automatically take effect from the date specified in the notice, as there was no provisions for any acceptance or rejection of the resignation by the employer. In Union of India versus Gopal Chandra Mishra, it was held in the case of a judge of the High Court having regard to the Article 217 of the Constitution that he has a unilateral right or privilege to resign his office, and his resignation becomes effective from the date which he of his own volition chooses. But where there is a provision empowering the employer not to accept the resignation on certain circumstances, example, pendency of disciplinary proceeding, the employer can exercise the power. On the contrary, as noted by this court in Dinesh Chandra Sangma versus State of Assam, while the government reserves its right to compulsorily retire a government servant, even against his wish, there is a corresponding right of the government servant to voluntarily retire from service. Voluntary retirement is a condition of service created by statutory provisions, whereas resignation is an implied term of an employer-employee relationship. So the law is very clear how a resignation should be considered and how it can be given effect to and from which date. Next, serial number 8, it is also on the issue of resignation. I'm referring to paragraph 10, Lordship.
Yes.
Next, in service jurisprudence, the expression superannuation, voluntary retirement, compulsory retirement, and resignation convey different connotations. Voluntary retirement and resignation involves voluntary acts on the part of the employer to leave service. Two, both involve voluntary acts to operate differently. One of the basic distinctions is that in the case of resignation, it can be tendered at any time, but in the case of voluntary retirement, it can only be sought for after rendering prescribed period of qualifying service. Other fundamental distinction is that in case of the former, normally retirement benefits are denied, but in case of the latter, the same is not denied. In case of former, permission or notice is not mandated, while in the case of latter, permission on the employer concerned is a requisite condition. Two, resignation is a bilateral concept and becomes effective on acceptance by the competent authority, yet the general rule can be displaced by express provisions to the contrary. Rest, I need not read. Repetition myself.
Yes.
Same principle, but different judgments.
Yes.
That's why. Serial number 9, I am referring to paragraph 32. This is on the correction of mistake by the government. Besides the ruling which my learned friend has relied upon on the issue of correction of mistakes. Paragraph 32.
Yes.
It is true that the mistakes was of the department and the respondent was promoted, though he was not eligible and qualified. But we cannot countenance the submission of the respondent that mistake cannot be corrected. Mistakes are mistakes and they can always be corrected by following the due process of law. In so-and-so, it was held that if erroneous promotion is given by wrongly interpreting the rules, the employer can be prevented from applying the rule rightly and in correcting the mistakes. It may cause hardship to the employees, but a court of law cannot ignore statutory rules. So far as our case is concerned, how the mistake was corrected? Has it done in a surreptitious manner? Has it done secretly without routing through the proper channel? When the representation was submitted by the petitioner, the department has sought clarification from the law department and the PNR department, even to the extent of referring to the accountant general, and arrived to a finding on the basis of the authentic records. Therefore, when a mistake is committed by the authorities, it is always open for correcting the mistakes.
Okay.
And one cannot say that the mistake is already committed, that cannot be corrected. That will not be reasonable logic.
Yes.
It can always be
So-
corrected in accordance with law
Yes.
by following the due process of law. I'm referring to a case which is not reported, but then from the life law, Lordship, recent judgment, serial number 10,
Yes.
flag 10. I'm referring to para 7. This is on the services rendered on casual contract cannot be said to be services rendered on substantive appointment. Para 7 also. Rule 13 of the 1972 rules provides for commencement of qualifying service. As per Rule 13, qualifying service of a government servant shall commence from the date he takes charge of the post to which he is first appointed, either substantively or in an officiating or temporary capacity. It further provides that such officiating or temporary service is followed without interruption by substantive appointment in the same or another service or post. Therefore, the services rendered on a substantive post or service rendered as officiating or temporary service shall be treated as qualifying service. Service rendered as casual, contractual cannot be said to be officiating or temporary service. Even the services rendered as temporary service can be considered as qualifying service, provided that the officiating or temporary service is followed without interruption by substantive appointment in the same or another service or post. Service rendered as casual, contractual cannot be said to be service rendered on a substantive appointment. So, the contract appointment cannot be treated as a substantive appointment. So, my initial appointment on contract cannot be treated as a substantive appointment.
Yes, the last one.
Last one, paragraph 28. This is on the continuity. I was the counsel for the petitioner here. This case is also pending in the apex court, Lord.
Okay, still pending, so we can't do
Yes.
this thing.
On the analysis
The
of
matter
the,
is still pending.
yes,
Then,
on the analysis of the factual metrics obtaining in the case of Srimati Asanglati Iyer, which has been referred to, Penjungdoshi, RT Assam, all these cases which I have referred to, it is noticed that the common question involved therein was about counting the period of 35 years of public employment of a government employee under the Nagaland Retirement from Public Employment Act 1991 as amended, whose previous period of service was of ad hoc contractual nature. In contradiction, the previous period of service of the review petitioner was in a regular post, while in the above four decisions, the matter involves service of two posts, with the service in the first post in a top contractual capacity under the government, followed by service in a regular post under the government. Whereas, in the case of the review petitioner, it is service rendered in a regular post under the government, followed by service rendered also in a regular post under the government. No similarity is found in the factual metrics obtaining in the aforestated four decisions referred by the review petitioner here with the fact situation obtaining in the case of the review petitioner, resulting in the alleged artificial or technical gap or break in between the two services in two regular posts without any impact in the continuation in the service career of the review petitioner, in the leave account of the review petitioner, in the salary and allowances of the review petitioner, etc. And thus, no support can be said to have been drawn by the review petitioner by citing the aforestated four cases. It is well settled that a decision is an authority for what it decides and not what can be logically deducted therefrom. It is also well settled that even a slight distinction in fact or an additional fact or different fact may make a lot of difference in the decision-making process. So, Lordship, keeping in view of all the principles of law laid down by this Honorable Court as well as by the apex court, the petitioner is not entitled to get any relief and the writ petition deserves to be dismissed, Lordship, at its threshold. I conclude my submission.
Any rebuttal?
Yes, Your Worship. In the first place, it is stated that several petitions are now filed in the Supreme Court. And those cases which are pending now, one has been filed as early as in 2012. on the issues. Then, despite that tendency of the case, all these decisions by our high courts, SB, DB, as well as full bench have been passed. And it is also learned that the Supreme Court has refused to grant interim
Okay.
in the apex court. So there is no stay. So as far as these decisions are concerned, passed by the our Gauhati High Court, still it is binding. Now, before going to the facts and the rebuttals, first I would like to submit that with all due respect, whether me or whether it's the opposite party, any counsels, don't make submissions before a court to make the other party understand his submissions. We make submissions so that we make submissions before the court so that the court can understand our submissions.
Right.
So it is unfortunate that my learned friend have not understood my submissions when I made the submissions yesterday.
Okay.
I mean on Thursday. And actually, I also have not understood his submissions today. With
Okay,
due
we have not
respect.
understood each other. That's it. I think the court has understood, so it's okay.
So as long as the court
Yes.
understood,
Yes.
it is sufficient for both the
Right,
parties.
Right.
Now, Your Lordship, let me take Your Lordship to the counter affidavit of firstly the respondent number 3. Paragraph 8. I'm sorry, 7. Paragraph 7 of the counter affidavit of R3. I'm sorry, I'm not going to read the whole portion. Fourth line from the bottom. Fourth line from the bottom, paragraph 7. At the extreme right after, in the fourth line after his resignation from the post of junior engineer, respondent number 3 never attended office since he has already resigned from the post. That is his contention. Now again, paragraph 8 at page 5. I'm sorry, paragraph 11. Paragraph 11. From line 6.
Para
Paragraph
11?
11, line 6.
6. Okay.
On getting the letter dated
Yes.
8/3/1989, the respondent number 3 submitted his resignation on 9/3/1989, and after his resignation, the respondent number 3 was not in active service of the government. Now, what is meant by not in active service? Then the other one in paragraph 7 is that he has never attended office. One may not attend office, but he'll be still in service. And then he is not in active service because he is not doing his duty, but he is still in service.
Okay.
And this, the statement that he is not in active service is also stated in the same paragraph, paragraph 11 at page 8. I'm sorry, not page 8. And continuation of paragraph 11. Third from the bottom, page 7, paragraph 11. However, the fact remains that from 9/3/89 to 16/4/89, respondent number 3 was neither a junior engineer nor assistant engineer civil, and during this period he was never employed under the government of Nagaland. Therefore, from the date of resignation on 9/3/89 from the post of GE and up to the date of appointment as assistant engineer on 17/4/89, respondent number 3 was not in active service of the government. Of the government, no salary was also paid during this period. Now, who will pay the salary? Should the government prepare his salary and go to him and give it to him? It is up to the employee to go and ask for his salary. So this is no excuse. It is not the case that he demanded his salary, but government refused or the department refused on the ground that you have resigned or that you are not in service. That is not the case. He simply did not attend office and alleging that he has not received payment or salary and contending that he is not in active service. This is important, Your Lordship. This is very important. Then the so-called resignation letter. To whom did the respondent number 3 submit it? Who received the resignation letter? Who? Who received the resignation letter? There is nothing. There is an initial on the paper. Whose initial? Will that be sufficient? Will that be sufficient to say that after submitting this letter, I have resigned from service? But the resignation is with a condition. It is not simpliciter. The condition is that to enable me to join that is the word? The new appointment. And no date, effective date of resignation also mentioned. On top of that, in terms of the appointment order of the respondent number 3 as GE, and in terms of the agreement executed between the department and respondent 3, there was no prior notice for resignation. The resignation letter is not a prior notice to the government for resignation. Those two are different. Those two are different. Then referring to the PIMS at page page 47 of the counter affidavit. I'm sorry, yes, counter affidavit. Page 47, in the column gender, now DOJ, this is date of joining. Date of joining is 08/03/1989. This is in the grade of assistant engineer. So normally, if we are to take the date of joining as on A389. Then the normal, the superannuation would be 24. And this is superannuation. Superannuation. That would be on the basis of age. And land of service, retirement from land of service is also different. Superannuation and land of retirement from land of service is different again. And the state list, page 44 of the same contract affidavit. At page 45,
When you say
preface.
60 years. So you're
Yes,
saying
superannuation
this
is
concerning
60 years.
Okay.
Yes.
Yes, not length of
Superannuation.
service. Huh?
Yes. Then page 45, preface to this civil list. In paragraph 4,
Yes.
it may be noted that the contents of the civil list do not confer any official sanctions in respect of the particulars given therein, such as an example, the date of birth and industry seniority of the officer. So these are not final. This not give any official sanction that these are correct. On the next slide. In case of any doubt or dispute, the correct information would need to be ascertained from the original records available in the department concerned. So this civil list is not final. It is only an information. Because another fact is that at page 46, our friend has already referred. Now in number 10 is respondent number 3. Now serial number 9, 10, 11, up to me, 11. And with another one, we were appointed by the same order. Now this serial number 9, Engineer Kahuli, her date of first entry into service is shown as 8/3/89. Now, your Lordship may see the writ petition at page 48. Writ petition at page 48. Because this engineer
Yes.
engineer
Serial number?
serial number 2, page 48, serial number 2. Engineer Kahuli Sema. Here it's column number 5. Date of first joining service is shown as 04/07/1988 as SDO senior. Before her appointment through the commission, she was on contract. Now in the civil list, her appointment on contract has not been reflected. In the civil list at serial number 9, Engineer Kahuli. Date of first joining of entry into service is only 8/3/1989. Taking the length of her service, she would have retired by June 2023, but July 2023. But she resigned from this post on 21st January 2023, and she contested in the last general election. To contest in the last general election, she resigned from the post.
So it's a resignation, isn't it?
Voluntary retirement, I'm sorry. Voluntary retirement.
Okay.
Yes. So we cannot rely on the least civil list, which the respondents are trying to do. Then according to the PNR and the views of the law department, that one is annexed to this counter affidavit also. Much reliance is given to the views and comments of the PNAR and the law department, which is at page 28. Your Lordship, allow me to refer to the petition. Page 54. Page 54. On receipt of the comments from the PNAR, it appears that the comments from the law department, the PNAR issued these views at page 54. Now first, one has to examine whether the comments or the views expressed in this letter is legally right or wrong, whether it is sustainable or wrong, or whether it is sustainable or not. Before giving effect to these views and comments, one has to see the legality and illegality, validity, whatever, of these views of the PNR and law department. Because they also says, may I read your Lordship?
Yes.
Number one, as per the affidavit in opposition filed by the state government of Nagaland in the Honorable Gauhati High Court, Kohima Bench on 7/9/2011, in case number so, in the matter of direct recruit, assistant engineer versus so, and others, wherein, as para 22, the state government has sworn that Engineer Yambemo was appointed as SDO and joined the service on 8/9/1989. Now, he was regularized with effect from 8/9/1999, including me, including Engineer Kahuli, and the other one. All were regularized from this day. But according to this PNR and law department, these two departments are now, the government is stopped to go back and to say that this R3 was appointed on 14/10/1987 as junior engineer. And so, his service in the rank of SDO is to be reckoned from 17/4/1989. Now, what this PNR is trying to do, they are committing an illegality. First, seniority benefit is given to him with effect from A3/89. Seniority benefit for the purpose of promotion is given A3/89. Now, for the purpose of counting the length of service or counting his entry point of service is to be from 17/4/89. Is it legal? Is it a valid view? No. One cannot choose that for consideration of my seniority and promotion, I'll take 8389, but to calculate my length of service for superannuation or retirement, I will count my service from 17489. That is not possible. Two views is not possible. And the question of estoppel does not arise because there is no question of estoppel. The government cannot be estopped in this manner. And to enforce the retirement rules is a statutory rules. Therefore, there can be no estoppel against the government. Estoppel, if the principle is available against individuals when something is promised but fail to keep that promise in principle. But here, there is no such things.
Okay.
And there is no estoppel against law. Therefore, the views given by the law department is totally misleading. And so, on the backdrop of such misleading views and illegal views, this cannot be relied upon. This cannot be acted upon. And therefore, the impugned order revoking the retirement of R3 is illegal. It is illegal. Then a question is raised that the government can rectify the mistake. Now, in the impugned order, did they specify any mistake which they have committed? No, they have not. Even in the respondent's own application, there was no mistake. The allegation was that March 1917 OM, by then that was already superseded and became redundant. And therefore, where is the mistake committed by the government in retiring the respondent on the basis of length of service? Nowhere in the comments, views given by the law department and PNER, they brought in the issue of estoppel. Otherwise, nowhere they said that taking the first entry point of R3 into service as on 15/10/1987 is legally wrong. That was not the view. Because of this, because of that, we cannot take this first point of entry into service as on 15/10/87 as wrong. That was not the view. The view was that if his entry point into service or public employment was counted from 15/10/87, then on his appointment as assistant engineer, and by the time the matter was referred to the PNR and law department, they said he would have superseded some of his colleagues. Where is the question of supersession? Because as submitted earlier, junior engineer is non-gazetted. Assistant engineer is class 1. Therefore, for the purpose of promotion seniority, there is no nexus between the two. But in view of the Retirement from Public Employment Act, now, first entry into public employment as junior engineer has to be counted. And when it is to be counted, now whether there is any break in service, that would be the that would be the question. And the respondent has relied on the Retirement Act, Para 3, 1 and 2.
Retirement Act. Just a Retirement Act.
Since that has already been read out, may I simply read out
Yes.
from this?
Okay, yes, okay.
The amended one to
OM, is it? August.
3. Second Amendment. 91 though, 91. 96.
Okay. 1991, this one.
I'm sorry, Your Lordship.
Nagaland Retirement from Public Employment Act.
Your Lordship.
That one. 1991.
No, not 1991.
Which one?
The Second Amendment.
Second Amendment, yes. 2009.
Yes. Yes, page 30 of the regional affidavit of R1 and 2. Page 30, that is the amendments of section 3. Section 3.
Yes, I think it's in 37 also of the affidavit in opposition. Okay.
No,
Second Amendment, 2009.
No, not this one, not this one.
Is it this one? Amendment of section 3.
Yes, but not this one.
Okay, let's look at your rejoinder affidavit. Rejoinder affidavit on behalf of. This is not what is enclosed, but something else. Yes. Rejoinder affidavit on behalf of
Resignation.
affidavit in reply.
I'm sorry, Your Lordship. I would like to refer to the OM, not that amendment one.
Okay, this is the amendment amendment of the act.
OM dated
Okay.
31st August 2017.
Where's that?
We can also find in the regional affidavit of R1 and 2.
August
Yes.
2017.
Yes.
Office memorandum.
Yes.
Counting of contract ad hoc work. Is it that?
Yes.
Yes.
Paragraph 6.
Yes.
Paragraph 6. Now
It says
therefore,
except resignation.
yes,
Thing,
except resignation. Now,
Yes.
what would be the meaning of this resignation?
Okay.
Now there is the respondents are hammering on this that R3 has resigned, but that was attached with a condition, with a rider. But here, except resignation will mean resignation simpliciter. There will be no attachment. There will be no condition. And resignation in its legal sense. if somebody submitted legal notice for resignation, the notice has to be complied with the acceptance of the authority. And there has to be a notice of resignation. This resignation would imply that not the manner in which the respondent number 3 has submitted a letter to resign with the condition. So that is not resignation in the eyes of law, which has already been settled by a full bench of this court also. And therefore, the submissions of the respondents on resignation, that is not tenable. The other thing is, now, therefore, the substantial question or issue involved in this petition is whether there is continuity of service or not in respect of respondent number 3. What is not disputed and which are relevant for the purpose of this petition is that he was on contract service as GE as on 08/03/1989. And it is not disputed that he was appointed as JE on contract from 15/10/1987. And till 8/3/1989, till 8/3, he was serving as junior engineer. Then on 9, he submitted a letter with a condition that he would resign to join the new post. Now, that is not the resignation letter, that is not a notice. Then he joined regular service as assistant engineer with effect from 8/03/89. And he joined the post of assistant engineer on 17/4/89. Then, on completion of the 2 years probation period, he was regularized with effect from 8/3/89. And his seniority was always counted from 8/3/89 in the grade of assistant engineer. Now, counting of seniority for the purpose of promotion is different from counting of length of service for the purpose of retirement from Nagaland retirement from public employment. Those two are different. We cannot club together, and then since his seniority is counted from 8/3/89 for promotion, his length of service is to be counted only from 8/3/89, though he has continued as junior engineer till 8/3/89. That is unrebuttable. He joined junior engineer until 8/3/89. He was working as junior engineer, and from 8/3/89, he He was appointed as assistant engineer. He was regularized as assistant engineer for the purpose of his seniority and promotion. Therefore, there is no break of service. The allegation that he has not been nowhere for 37 days, that is absurd. Where was he? He says he was not in active service. Where was he? He says he has not received his pay. Did he demand his pay? Did he ask for his pay? No. He did not ask.
Okay, he was not paid during these how many days? 37, a few days.
According to them,
because
it is
he did not-
37
he did not-
days.
37 days.
But there is
because he did not demand his pay.
no
37
demand.
days is 1 month. Around
He
1
has
month.
never demanded.
Okay. Since he was not demanded, he was not paid. Actually, he was supposed
In
to
fact-
get his pay as you're saying junior engineer.
Yes. But those are in fact immaterial for the purpose of this. Because seniority promotion, immaterial. Whether getting pay or not, immaterial. How much he got for the month, immaterial for the purpose of Nagaland Retirement from Public Employment Act and OM dated 31 August 2017. Close paragraph 6.
Yes.
Yes. The only question here is continuity, whether continuity, that is one, and resignation. So there was no resignation at any point of time. Be that as it may, on 8 March 1989, he was junior engineer. And on 8/3/1989, while remaining as junior engineer, his appointment as assistant engineer was made effective. His regularization was made effective. He prayed for regularization with effect from April, but that was not accepted by the government as seen in his representation, but it was made 8/3/1989. And there was no agitation for that on the part of the respondent number 3. So those are the accepted truths. The rest are all rather immaterial for the purpose of this petition. And on the question of maintainability, now on the ground of non-implement, the AG has nothing to do with the question of whether a person should retire on the basis of Nagaland retirement from government employment. AG has nothing to say.
Okay.
The second one is, after issuance of the impugn order, he was retained in service. He is in service, but he has not been provided with any room till date. But he is still in service.
Okay.
Yes, he is still in service in view of the impugn order, but he has not been provided with any office. So this petition was filed after revocation of the retirement order. After, in that case, what has AG to do with? There is nothing we have to do with AG. AG has no role to play whatsoever in this petition. Now, secondly, on the ground of allegation of no legal right, that is only a whimsical ground because now the respondent number 3 was made to retire from 31st October 2022. Before he retired, the senior engineer Kahuli was engineer in chief. Gauhati was engineer in chief. Now, R3 is in number 2, seniority wise. So, on the retirement of Srimati Engineer Kahuli, R3 would have been considered for promotion to the post of engineer in chief, but for his retirement on the land of service. Now, after R3, I'll be in the first position. So, there is a legal right to be considered for promotion to the post of engineer in chief. DPC will consider, but what type of submission is that, Your Lordship? Because DPC is going to consider our promotion, I have no legal right. How such submissions can be made? Because at the most, 3 senior-most officers is to be placed before the DPC. Then, where is the question that I have no legal right to be considered for promotion? That is absurd, Your Lordship. That type of submission is absurd. And therefore, since I would have been considered for promotion on the retirement of R3, but because of his revocation of the retirement order, now my right to be considered for further promotion has been breached.
Yes.
Has been breached. Now, in one of the case which I have submitted yesterday, in that case, now some persons, a group of persons, officers, challenged the officer who is supposed to retire, but he was not retired. So some officers, they challenged that group. And the contentions of the petitioner is that the respondent in the case is that they are strangers. They are strangers and no read will lie. But the views of the division bench in that case was totally different, and that there are no strangers. They are all working in the same department. And if this is done like this, they will be affected. So co-rental would lie. That was the finding of our own division bench. And therefore, full bench. Therefore, there is no question of non-maintainability of the petition on those 2 grounds. Then, now, pensionable post. Pensionable post also has been very much emphasized. And in this connection, allow me to refer to flag E of the authorities submitted yesterday, Your Lordship. Flag E. There's a full bench judgment in the case of Asanglati Iyer. E. Flag E. Just to clarify, what is public employment? Paragraph
Yes,
2.
flag E.
Yes.
Pensionable post.
Yes.
What does
From
it say?
Paragraph 2, paragraph 3, I would like to read out. May I read, Your Lordship?
Yes.
This full bench has been constituted on a reference made before it by a division bench of this court.
Flag
by-
E, isn't it? E.
Yes, flag E.
So, para?
Paragraph 2.
Yes.
This full bench has been constituted on a reference made before it by a division bench of this court by an order dated 10/2/2021, while hearing WPC number 198/2019. Srimati Asanlakti I versus Srimati Tundeno Mujui and others. The matter referred is as follows. Whether the definition of public employment referred above would necessarily mean that a person has worked on a post which was pensionable or will include contractual/ad hoc service as well, which are non-pensionable. 3. Apart from giving our findings on the question referred to us, the full bench has also been called upon to decide WN number 16198/2019 on its merits. Hence, we begin by giving a short background of the case. So, background,
Okay.
we'll come to paragraph 9. Your Lordship, I'm also relying on this paragraph 9, but due to paucity of time, let me skip that one and go to paragraph 15. Paragraph 15.
Yes.
A learned single judge of this court, who is one of the members of this full court, so and so, had already given a judgment on this aspect in so and so versus State of Nagaland, wherein it has been held that the essential element in public employment is that one is entitled to, for pensioner benefits for the entire 35 years. In paragraph 48 of the judgment, it was stated as under. Perusal of the aforesaid definition clause of the words public employment clearly indicates that such appointment would be a public appointment if the appointment is made to any pensionable state public service or post connected with affairs of the state of Nagaland, etc. And such service should count for the purpose of pension. In other words, the employment must not be only be against a pensionable state public service or post connected with the affairs of the state of Nagaland, but also such service must count for the purpose of pension. Accordingly, on conjoint reading of section 3.1 and definition clause under section 2.1 of the Act, the following position emerged. 1. A person in public employment can hold office for a term of 35 years from the date of his joining public employment or till he attains the age of 60 years, whichever is earlier. 2. The appointment of such person must be in pensionable state public service or a post connected with the affairs of state of Nagaland and such other authorities mentioned in the Act. 4. Such service rendered by the employee must count for the purpose of pension. As a corollary, if the appointment is not against a pensionable state public service or to a post not connected with the state of affairs of Nagaland, and if it does not count for the purpose of pension, the said service cannot be counted to compute 35 years of service as mentioned under section 3.1 of the Act. Therefore, in the present case, we have to examine as to whether the service rendered by the petitioners after being appointed by order dated 11/2/1983 till they were appointed to the post on 30/8/1984 fulfills all the aforesaid conditions as to be counted towards computing the aforesaid 35 years of service within the meaning of the Act. Now, I'll come to 17. In other words, the entire period of service will be counted for pensionary benefit irrespective of the fact whether it is regular, contractual, ad hoc, or otherwise. In other words, we follow the law laid down by the division bench of this court in writ appeal number so and hold that public employment would include contractual ad hoc employment provided it is continuous and the entire period, not beyond a period of 35 years, shall be counted for pensionary benefits. So, so continuous. Now, here also that issue is here. Whether the service is continuous or not.
Yes, provided it is continuous.
Yes. So, to show that it is a continuous service, I'm referring to his remaining as junior engineer till A389. And his appointment as SDO was with effect from A389. And regularized with effect from A389. And so, for retirement benefits, for 35 years of service, his service rendered as junior engineer has to be counted. Your Lordship, due to the paucity of this time, although we will read other paragraphs which has been reflected in the paper book list, we have not. So may I request, because Your Lordship is very busy, I know, but if Your Lordship would have time to go through these cases,
yes,
with the, have a review of that and then come to a conclusive decision, Your Lordship.
yes.
And
This Asangla T. Iyer, this judgment,
and because
okay, is it pending in the
Apex Court, Lordship.
although pending,
It is pending, isn't
Yes.
it?
it
In
is
the Supreme
pending,
Court?
but
Yes.
there is no stay.
Okay, pending but
Stay,
no stay.
yes, stay was prayed for, but refused. Refused.
Okay.
One
If
thing which
case
is
numbers are
required
required,
to be
we can
remembered
also
is,
submit.
Lordships, in this judgment, the service has to be pensionable service and it should count for pension.
Yes.
My learned friend has not referred to paragraph 14, which is very clear. And in all cases, continuity has to be there. And there is not even a single case out of many.
So
Even if-
your point is clear. One is saying that there was no break, the other is saying that there was break, isn't it?
Yes.
Coming to the short gist.
Yes.
Yes.
Okay, yes. I think we are done. Time is also almost, anything to mention?
Otherwise, Lordship,
Because we
within
don't know.
3 minutes time,
You don't have to repeat your points
I
because
can
I think I
clarify,
have understood.
clarify all these things within 3 minutes, Lordship.
Okay.
In fact,
yes.
we can go on clarifying because I also have not
Yes,
clarified
after
many
his
things.
clarification, again
Because-
we'll have to clarify.
Yes,
I think I've got your points.
Lordship.
It's a rebuttal of your point, so you're going to go back to your point only, isn't it?
Yes.
Some new things have been added. That's why I want to
like
clarify
which one?
on
What
that
is the new
point.
thing?
But the law laid down by the ethics court should prevail, or anybody's wishful thinking should prevail.
Okay, so you're saying there's a judgment of the apex court in this matter, isn't it? I think
Your
we're
Lordship, we
done.
appreciate Your Lordship's
This
patience.
is a CAB matter, okay? Yes. Heard, one more is there? Okay, this is one more
Lordship, I'm
matter.
also relying on one citation, Lordship, 2007, 10 SCC. It's there in the report. But I am not on natural justice.
Okay,
I'm also relying on paragraph 17, 18, and 19. 2007, 10 SCC.
it's there, isn't it?
Lordship,
Oh.
it's there, Lordship. 4. I'm also resigning.
Noted. Yes, because 2 days of hearing, so it will take time for me to peruse the matter also. But we'll dispose it off as soon as possible. Definitely. Yes, there's one more matter, I believe.
For admission, item number 36.
Oblige, Your Lordship.
I believe there is no conceal.
36 is, we haven't called out before? Okay. Matter is called out, none appeared for the parties. This is matter after 3 weeks. Yes.